2009 to 22/5/2009. And number two, whether the workers will be entitled to get full wages and rations for and during the lockout period if they're partially responsible for the lock. Now, these are the issues. Now, my lord, that both parties adduced evidence written statement. The learned tribunal had held that the lockout is illegal because the lockout was in violation of section 22 of the Industrial Dispute. I straightway take your lordship to the finding of the tribunal. Lordship may come to page 24 is the findings and reasonings of the tribunal in the award.
Yes.
Now, the third paragraph. Peruse the evidence adduced by both sides minutely. Peruse also written arguments submitted by both sides. The gist of this case is that washerman of the tea estate named so-and-so had assaulted the then senior manager, and ultimately management had declared lockout in the tea estate. Witness number one in his cross-examination had admitted that he did not lodge any FIR in the police station regarding the aforesaid incident. He further admitted in his cross-examination that before declaration of lockout, he did not file any complaint before the law and order authority about apprehension of law and order situation. As per management witness number two, after the aforesaid incident, management had informed the matter to police station, but he had no knowledge whether any police case was registered or not. In the aforesaid case, management, this is very important. The management has declared lockout in the main division of Unnavan Tea Estate without giving any notice as provided in section 22(2)(a) to D of the Industrial Disputes Act. As per section 22(2) of the Industrial Disputes Act, no employer carrying on any public utility service shall lock out any of the work. Now, my lord, and then it says, as per section 23 of the Industrial Disputes Act, no employer of any such workman shall declare a lockout during pendency of conciliation proceedings before the court and 7 days after conclusion of such proceedings during the pendency of proceedings before the labor court, tribunal or national tribunal, or within or 2 months after the conclusion of such proceedings. So, my lord, may have a look at section 22.
Yes.
Now, section 22 says the prohibition of strikes and lockouts. Now, we are governed by section 22, subsection 2. No employer carrying on any public utility service shall lock out any of his work. Now, the issue is whether the tea estate is a public utility service. Your lordship will come to the definition of public utility service in section 2(m). Section 2, small one. Public utility service means any railway service or any transport service for the carriage of passengers or goods by air.
Yes.
So there is a list of services. Any services or in connection with the working of any major port or dock or any industrial establishment or unit engaged in essential defense service. Any section of any industrial establishment on the working of which the safety of the establishment or the workmen employed therein depends. Postal, telegraph or telephone service, any industry which supplies power, light or water to the public, any system of public conservancy or sanitation, any industries specified in first schedule which the appropriate government may, if satisfied that public emergency or public interest so requires by notification in the official gazette declared to be public utility service for the purpose of this act and for such period as may be specified in the notification. So, my lord, there is a list of services in first schedule. So, nowhere it is provided that tea estate will be a public utility service.
What about in the schedule?
My lord may have a look at the schedule. Schedule 1.
Where's the schedule? Let me see.
It
Schedule.
is
Schedule
1.
44.
Yes. Now, in my book, it is at the end of the Industrial Disputes Act. First schedule. industries which may be declared to be public utility service under subsection six
Just
of.
a minute, let me get the page.
Immediately after the act, before the rules,
I've got the,
after section 40.
after section 40.
The first schedule.
Yes,
Now, industries which may be declared to be public utility services under subclause 6 of section clause N of section 2. Banking, cement, coal, cotton textile, foodstuff, iron and steel, defense establishment, service in hospitals and dispensaries, fire brigade, India government mints, India security press.
okay, so it's not there.
And there is the public utility service, the act provides that the government has the power only in respect of the industry specified in the
Schedule.
first schedule and for a period.
6 months,
3 months or whatever. it
6
is the-
months.
Yeah. So this tea industry is not a public utility service. So the provision of section 22 doesn't apply. The requirement of giving notice, because if a lordship comes to section 22, no employer carrying on any public utility service shall lock out any of the workmen without giving them notice of lockout as provided, herein provided within 6 weeks before locking you out. So, my lord, the prior notice, issuance of prior notice will be required only when it is a public utility. Now, in this case, the industry or the garden not being a public utility service, the section 22 doesn't apply. So this, my lord, the London Labour Court had held the lockout to be illegal because no notice was given. And my lord, London Labour Court has Industrial Tribunal also taken into account that section 23. Now 23 doesn't apply at all, my lord. Section 23, general prohibitions of strikes and lockouts. No workman who is employed in any industry shall go on strike in breach of contract, and no employer of any such workman shall declare a lockout during pendency of conciliation process.
So there was no conciliation procedure.
Yes, there was no conciliation proceeding pending, no award or settlement in operation. So,
No proceedings before the labor court.
yes, ma'am. So the section 23 also doesn't come into play. The learned tribunal had held the lockout to be illegal only on this count. Then, my lord, there is another perversity. Then I'll take your lordship to the next page. In the present case,
Yes,
the management has declared lockout in the main division without issuance of any notice as provided under section 22A to D of the industrial law. That is the main reason for declaring it to be illegal. And section 23, when section 23 doesn't apply at all. Moreover, management witness also admitted in their cross-examination that no law and order situation prevailed at that time which justifies the management to declare lockout. Now, this is another perverse finding. I take your lordship to the management witness, which is recorded in the award matter. Lordship may turn to page 19 and 20.
of the award.
Of the award. Page
Yes.
19, it is the cross-examination of the management witness number 1, my lord. 8th line from the bottom, my lord.
Yes,
He denied in his cross-examination that no law and order situation arisen which justifies the management to declare lockout. So the suggestion was there was no reason to declare lockout, or there was no reason or the situation was not there to declare lockout, which he denied. And my lord may come to page 20. Here also the management witness number 2, in the middle of that, my lord, paragraph. He denied in his cross-examination that no such circumstances prevailed for declaring lockout on 24/2/2009. Nineteenth line, man.
Yes.
Page 20. So the witnesses had denied the suggestion that there was no such situation. And the learned tribunal had held it to be otherwise, as if he has admitted that there was no bad law and order situation. So one aspect is there is no applicability of section 22 or 23. So the decision of declaring the lockout to be illegal as a consequence of such declaration, directing the management to pay wages to the workers during the lockout period is bad matter, cannot be sustained. And number two, it is also a perverse finding because the witnesses had not admitted the fact. They have denied the suggestion that there was no bad law and order situation. And number three, my lord, the management, no,
So we'll send it back to the tribunal. Let them decide. Okay. Because he has not gone into the reference at all.
yes, and what has been decided by the tribunal is something beyond. The question was whether they are
Anyway, what,
entitled to
no,
wage.
no, if it was applicable, then it's okay, but it's not applicable.
Not applicable. So the
So let
question
it
of
go back.
No, question arises, my lord. Lockout, apparently, my lord, one casual employee who was
Ah.
temporarily engaged by the management had assaulted one manager, assistant manager company. On that count, lockout. That means they should punish that man who was casual. He was not the permanent worker.
No, no, you see, whatever, that is the merit for the case you're going into. I'm going into the
Basics of
correctness,
the
the
law.
correctness of the decision of the tribunal. The tribunal has gone on a wrong assumption
Yes.
that section 22 and 23 are applicable. It is not applicable. And
There was
also,
a constitutional proceeding after the lockout was lifted. Okay. There was constitutional proceeding.
after the lockout, so this is 23 comes into play during the conciliation proceedings when the lockout is there. So that's so, I mean, then let it decide afresh, because it has not gone into
real
the
question
reference,
for
the
it.
real question. The real question will come into play now. It was okay if 22 and 23 were applicable. But since it is not applicable, then it has to go back.
Yeah.
है ना?
That I also wanted to submit at the very start because I've also gone through it.
हाँ,
Law
that's
doesn't
it.
support the case.
Okay. How do I record your submission?
No, I
You object.
will not record anything. Simply say, after hearing both the sides, this is the order.
I will record his submission. Yes. Then I will.
My
What do I?
submission will, my submission will matter. There was no law order situation as such because one casual employee is.
So should I say that? No. So should I say that there was no law and order situation,
To call for
and
lockout.
the award should be upheld?
Yes.
Huh?
No.
That's all.
There was no law and order situation to call for lockout. One casual employee assaulted the person of the garden, and that could not amount to causing sufferance to the entire garden workers. That's my solution.
Okay, right. Heard. Mr.
S. Chakraborty for the matter.
S. Chakrabarti, learned counsel for the petitioner. Also heard Mr. R.P. Sharma, learned senior counsel for the respondent. Respondents.
Respondent number 2, union.
Point number 2,
Yes.
assisted by Mr. D. Dalai. Mr. S.R. Barua appeared for point number 1, huh? Yes, Mr. Barua, what do you say? Do you agree with the submission made by the petitioner's counsel? Huh? No. Have you heard? Have you heard the submission made? Have you gone to gone through section 22? Have you gone through section 22? No. This was the suggestion made by the court. His submission was that section 22 is not applicable. Section 23 is also not applicable. Do you agree with that? You have no idea.
In their affidavit, they have not raised any question.
Then please at least try to understand what he's trying to say. Here, the main protagonist, the main adversary has also agreed that what his submission is correct, and you you have no idea. Please try to understand. Right. The petitioner has prayed for setting aside the award dated 30/06/2017 passed by the Industrial Tribunal Kachar, Silchar, in reference case number 5 of 2010, wherein it has held that the lockout declared by the management tea estate, management of the tea estate, by ordered no, for the period 26/02/2009 to 22/5/2009 was not justified. As the management was not justified in denying the payment of wages and rations to all eligible workers during the lockout period, comma, the respondent workers were entitled to get full wages and ration during the lockout period. Next paragraph. The petitioner's counsel submits that no, don't say that. Just the facts of the case is that due to an assault, due to where is that assault? Assault by whom?
My lord, your lordship may come to paragraph 5 on that on
Paragraph 5.
the writ petition on 22/24/2, the garden, Dhobi and.
Just a minute, just a minute. Paragraph 5.
Yes.
The facts of the case is that on 24/02/09, the garden Dhobi and his sister had manhandled the senior, had allegedly manhandled no, that is not denied, no? That manhandling
That is not denied.
had manhandled,
Denied is mallet, he was not employed with the garden, he was casually employed as a token.
had allegedly manhandled, no, had manhandled the senior manager of the management in the garden office. A lockout was thereafter declared by the management on 26/2/2009, and the same was lifted on 22/5/2009. The workers of the tea garden thereafter made a claim for wages for the lockout period. The conciliation proceeding that was initiated due to the claim made by the workers of the tea garden having ended in failure, the government of Assam wide notification dated
18th March 2010.
18/3/2010 referred the following issues for adjudication by the Industrial Tribunal, Kachar Silchar,
Industrial
which
Tribunal.
which are as follows. Para 9, page 5, 1 and 2, in bold it is there. Okay, next para. The learned tribunal thereafter came to a finding that the lockout that had been declared by the petitioner had been done without issuing any prior notice, as required under section 22 bracket A small a to bracket small d of the Industrial Disputes Act, 1947.
22 to A to D.
That's what I said, 22 bracket A,
No, 22 bracket 2.
Acha.
Section 22 subsection.
bracket 22
Subsection
bracket 2, bracket small a, 2 bracket small d, of the Industrial Disputes Act 1947. And no, first stop. No, wait, no, before that, before to D and section 23 bracket A, two bracket A and B, small b of the Industrial Disputes Act 1947. Okay. First stop. Further, the as there were further in the cross-examination of the management witnesses, it was proved that there was no law and order situation, had admitted the management admitted that there was no law and order situation prevailing at the time, which justified the management to declare the lockout. As such, the learned tribunal came to a finding that the lockout declared by the management from 26 to 2009 to 22/5/2009 was not justified. And the workers were thus eligible for payment of their wages and rations during the lockout period. Next paragraph. The petitioners' counsel submits that section 22 bracket 2 bracket 8 to bracket D of the Act only pertains to public utility service. And does not pertain to a tea garden. Further,
Public utility services defined in section 2N.
further, section 23 of the Act does not come into the picture inasmuch as the lockout had not been declared during the pendency of any conciliation proceedings or during the pendency of any other proceedings before a labor court, tribunal or national tribunal. Next paragraph. The petitioner's counsel further submits that the cross-examination of the management witness number 1 and 2, as recorded in the impugned award, clearly goes to show that MW1 and MW2 had denied the suggestion that no circumstances had prevailed for declaring a lockout. And that no law and order situation had arisen which justified the management to declare the lockout. Next paragraph. The petitioner's counsel thus states that the impugned award should accordingly be set aside as the findings of the learned tribunal for declaring the lockout to be illegal, illegal, illegal was not supported by the act, the provisions of the act, and the evidence of the management witnesses. Full stop. Next. Mr. R.P. Sharma, the learned senior counsel for the respondent number 2. On the other hand, submits that the
My submission,
senior manager
Yeah.
of the management had not been manhandled by the workers,
any of the regular workers.
by any of the regular workers of the tea garden. What else? That's all.
The alleged assault was by one of the casual employee at Dhobi.
The assault, the assault on the senior manager had been done by a casual employee
Yes.
who was a Dhobi.
Dhobi. And other man is my reason is that assault by one casual employee, Dhobi manager, who was not participant to cause law and order situation is to declare lockout.
He further submits that the assault by a casual employee on the senior manager of the garden did not lead to such a situation wherein it required the declaration of a lockout of the garden, thereby depriving the workers
Yes.
from earning their livelihood.
Yes.
That's all?
Yes.
Next. Yes, okay, Mr. S.R. Barwa, the learned counsel for the respondent number 1, submits that that the impugned award, that there is no infirmity with the impugned award and the same should be upheld. That's the case, I guess. What else? Not followed, okay. Then cut that. We just say Mr. S.R. Barwa, learned counsel for the respondent number 1. Admits to the fact that the impugned award could not have been passed on the basis of Section 22 bracket 2 A to D and Section 23 A and B of the Act. Next. I have heard the learned counsel for the parties. Section 22 to A to D and Section 23 A and B of the Act states as follows. The next para, Section 2N of the Act defines public utility to mean public utility service to mean. You take it down. It's from page 11. It will.
And also under
At the
Schedule
bottom.
1 to the Act.
Huh?
And also under Schedule 1 there.
No, that is already, I have already mentioned. Full stop. Next para. A perusal of section 2 bracket N and schedule 1 to the act clearly shows that the tea garden does not come within the meaning of public utility service. Next paragraph. In view of the above reason, it is apparent that the learned tribunal has made a completely wrong finding and applied and a completely wrong finding with regard to the issue of whether the lockout declared by the management was illegal without realizing the fact that the management tea garden was not a public utility service. Pusta. Next paragraph. It is also not the case of any of the parties hearing that there was any conciliation proceedings or any other kind of proceedings before the learned labor court, tribunal or national tribunal during the time a lockout had been declared. In view of the reasons stated above, the finding of the learned tribunal, the finding of the learned tribunal that there was a violation of section 22 bracket 2 A to D and section 23 A and B of the Act is not sustainable and the same is accordingly set aside. Next paragraph. The question as to whether the management witnesses had admitted in their cross-examination that law and order situation prevailed at the relevant time, which justified the declaration of lockout by the management, can be seen from the cross-examination of MW-1 and MW-2, which is reflected in the impugned award dated 30/6/2017. The cross-examination of MW-1 in its cross-examination is as follows, Page 19, from he denied till lockout, okay, page 19, and then next para, you write, no, there's sub para. The cross-examination of MW-2 is as follows. The extract of the cross-examination of MW-2 is as follows, page 20 in red, okay. Next, a perusal of the above clearly goes to show that the management witnesses had not admitted the suggestion made to them that there was no law and order situation and that the circumstances were not prevailing at the relevant time for declaration of a lockout. First up, as such, the finding of the learned tribunal with regard to there being no law and order situation prevailing at the time, at the relevant time, which justified the declaration of a lockout as per the evidence of the manager and witnesses has also been made, not only without any basis, but also in direct contradiction to the evidence given by the management witnesses. That's all. Anything else?
Only one thing, my lord, Mr. Lordship, remanding the matter back. My lord, that finding that, any witness that, quotation by lordship. Because, the workman witnesses are also there.
Huh?
Evidence of workman witnesses are.
No, that is different. You see, why I'm saying this is because he has said the management witnesses have admitted.
Yes.
There's no admission.
No illusion.
There's no admission. That is why I'm saying this. He's saying it. He's saying this. They are saying it is white, and the tribunal is saying what they have said is it is black.
Black.
That's all. I'm just saying that's in direct contravention.
Now look into everything.
I know. Right. Next para. On considering. No, next para. In view of the above reasons, comma, this court finds that the finding of the learned tribunal that the lockout declared by the management was not justified, which was not justified, is not sustainable. The same is accordingly. The Impune Award dated so and so, dated 30/06/2017, passed in reference case number 5 of 2010, is accordingly set aside. The matter is remanded back to the learned tribunal to consider the matter afresh without taking recourse to section 22, 2A to D, and section 23 of the Act, A and B of the Act, and to decide the reference on the basis of the materials on record. And the writ petition is accordingly allowed. Okay. Put this.
But, we can use the order, there's a P5 daily. The penalty that's there.
Yes.
But, I have not received the written instruction, but the telephonic instruction is that, already it is processed by the home department. And the file is now with the highest authority, with the highest authority, the file is placed. Well, after the approval of the authority, they will send it to the finance department.
Why? Why highest authority?
Well, in any case, since the finance is involved, ultimately the approval of the department.
You see, finance had already given approval earlier,
No, that.
and because of your intentional delay, now there you need the revalidation of the sanction.
Well, ultimately, the amount has to be in the new budget.
Huh? Correct.
Amount has to be in the this year.
You see, you owe them the money
That's true.
and you're delaying and you're using all the tricks in the book
No,
to deny them payment.
so kindly may not be considered that fee. These are procedures where they have to follow. But kindly.
Look, it is simple. It is a issue of
True.
it is an issue of him completing the work long time back. It is an admitted amount. You have also made a proposal to the finance department for payment.
Malad,
Now,
think-
that finance department had approved the amount. You did not pay. And now when he comes to court, you're saying that, sorry, there was some mistake, there was a lab delay in payment. And now we want to again have the same process of fetch from the very beginning
Malad,
so that we can pay him, which will take time. And now it is with the highest authority or some authority. And thereafter it will be again sent to the finance department. What is this? This is just the delaying tactic.
already,
All cases are coming like this.
already the process was there, Malad. Ultimately for some reason, Malad, it could not be paid within the last financial year.
What is the some reason?
But in fact.
What is the reason? What is the some reason?
But now they are in the process. Malad,
They are in the process. They were always in the process.
Malad, in fact, now they have placed it before the high authority. Kindly take up after 2 weeks. Malad. They are doing it. They will send it. They will send it.
They will send it to whom?
Malad, after the approval for the finance, otherwise the clearance is already there. Malad. Finance is already clear because of time lapse. Malad. Some time lapse, time is a factor, Malad, for the authority. Ultimately, the procedure they have to follow. Malad. They cannot ignore the procedure. That is the difficulty they have.
Look, you all owe people a lot of money, a lot of contractual dues, where you have admitted the dues and you have given them orders to construct buildings, to make roads, to make supplies, and they have used their own money. They have not used your money to supply.
Malad.
They have used their own money to supply. And you are delaying years and years payment.
Here, Malad, because of some approval related thing, Malad, some problem has occurred. That has been already taken care of. We have filed a detailed affidavit in that matter. I'm not on that, not taking lordship to that. And ultimately, give them some time, Malad. The process is on.
You see, ultimately what happens is they're losing out on interest. They can put it in the bank and earn some money.
But,
What is the bank interest now? We'll have to start imposing interest now. If you keep on, if this is your thing, you take 10 years, 20 years, but we'll impose interest.
this may not, this may,
This,
this
I
may
mean,
not
this
take
is
long.
not a one-off case. I can understand if it's a one-off case.
That's-
It is every day, how many cases are coming to this court? Only with regard to non-payment of admitted amount, not even disputed amount, admitted amount.
But, Lordship, case to case, Lordship has seen, Malad, what is the reason? Ultimately, that has to be seen. Here,
Ultimately, what has to be seen is this.
Malad, amounts are being paid.
No,
Malad. They
please
are being
listen,
paid.
please listen. You see, there's not only you keep on just talking without hearing the court. When you give a contract to some person, do you give it with the fact that some money is already there with you for payment of the contract work, or is it I do not know how you give contract. Is it with the thought that, okay, let him do the contract work, then we will think of how to get the money later on, and then we'll pay slowly by slowly. The money should be in your hand. You're asking him to you're asking him to do something.
The earmark amount.
Yes, you have to earmark the amount and keep it with you. Or ensure that it is somewhere, parked somewhere. Or you're just saying that, okay, do your work, we will pay you as and when we deem fit.
No, of course,
The value of money decreases.
Here in this case, Malad, the approval, whatever was approved, that has already been paid. Now some additional work was done, that is why fresh approval thing has come.
Maybe additional work also requires money.
That's true.
Then
Without
if you don't have, if there is no approval for the additional work, I don't think you can ask him to do it. Additional work needs approval. Without approval, there can be no additional work.
without the approval, it was done.
Ah.
We are not on that because ultimately they have regularized that. Now they have taken the process to payment. So it is the file is with the authority, Malad, after the authority.
File has always been with the authority. It can be with no one else.
Kindly see, Malad, ultimately the process they have to take the approval of the highest authority because finally
At the time, you see, highest authority is not the issue. A highest authority cannot do everything. I think responsibility and accountability is given to all departments. How much money they can sanction, how much approval they can give, everything is there in place. Now, when everything is there in place, you have asked him to do something, it's your duty to pay him. Why should he come to court? Why should he come to court in the first place? I can go on for another half an hour also, only on this, so many cases, I can give you a list.
That's true. I can't deny that.
It's not only you, BTC also. Thousands of, I mean, for them, I think it's thousands of unpaid bills. They made a list of, I think, 2,000 plus unpaid contractors.
Not a lot of them. In fact, regularly cases are coming.
Not, it is a everyday affair, every day. You just see every day there are unpaid bill cases, and not only unpaid, admitted. And they're least bothered.
But I would only say that process are being taken, and the amounts are being paid, but there is some time is taken, that's true. But amounts are being paid, they are getting it.
Amounts are being paid, but you see, 10 rupees today and 10 rupees in another 4 years' time, I think there'll be a difference. Cost of everything goes up.
That's
Then and then this case is a case where approval has been given, sanction given by all the authorities last year,
because of
and you have not paid for whatever reason, I don't know.
because of
Now you all are saying we need to again have a revalidation of the sanction. Why you have to go again through all the 20, 30 desks? It has to go.
no, it will not go. I don't
See?
know that I have.
What is this?
I have the instruction.
This
It
is
will not-
this
it will
this
not go.
is it deliberate? This intentional delay in payment? It appears to be.
But as I have been instructed, with the procedure they have to follow. I would not say it is deliberate.
It appears to be deliberate. Appears to be deliberate. But then you see now, uh, you see, there might come a time where interest will have to be imposed. Otherwise, they won't learn a lesson. And then you can then it be as good as parking money in the bank. So they won't even file cases. 20 years they'll park it with you.
That's not that.
No income tax also, because there's no money given to it. You see, this is not the way.
Interest not mine. It's difficult for me to say at this stage.
I know you'll be knowing a lot of things with which we don't know. But we only know what is in front of us.
Yes, I look, the construction regarding assigned human rights commission building. Down completed by around 80 or 22.
No, I was there when it was inaugurated also.
And there the proposal of the highest authority, which my planet is trying to advise is of the highest authority. Why not is it possible that this proposal is already given and the approval of the highest authority was taken? Again, why it is required?
Correct. All authority, all sanctions, everything given.
This year's budget, that amount in course may not be clear.
Is it because the money that was supposed to be given to him last year has been diverted somewhere else? And now you don't have money this year to give him?
It is not.
You see, when it was sanctioned by the finance department last year, that means the money was there. Naturally, unless you had a zero account for it and you Namka Vaste say you gave a approval.
Not a sanction. They would not give sanction like that.
So if the money was there last year, you didn't give it for whatever reason. Why couldn't you give it this year? Revalidate the entire thing.
That is.
Correct.
that is-
That is there. If it is still there, if it is not used, somewhere else, diverted somewhere else, it should still be there unless you have used it for something else. You'll know best. But then the thing is that this is not the way to treat your citizens. I mean, it's not, you see, not every day I get this case. It's not, I mean, it's not every week or something. Every day I'm getting it.
Lordship, has clarified in the order, but I have also communicated the order, but I'll place the appellate position. Can we?
No, we'll call your officials.
But, but my response submission was I have, the order is before them, and then they are in the process. I have been instructed about the telephone, calling the officers, but at this stage,
No, because you see, one thing is that either they're not giving enough attention to this case.
no, it is not, I have, in fact, the Lordship's order, of 2nd of May, I have communicated it on 3rd of May. They are not working on that. I have been telephonically also instructed. They are working with that. It is not that they have just left it without doing anything.
You see, this is not a case. This is not a case that should take up the time of the court. Admitted amount. You have taken whatever you have from them. Now give them back you see, you have taken their services. You pay them.
Not
It
that
is a simple thing.
there is no.
These type of cases should not come to this court. This is a accepted amount, admitted amount. This should not come to the court. I can understand
I have,
cases where the amount is not admitted, where there is some adjudication required. Out here, no adjudication is required.
this is not a case of that.
Then nothing is required.
True.
It's only on your part, you've got to ensure that you pay, that's all. Now, why didn't you pay? At the time of allotment of the contract work, wasn't the money there? Nothing, you have kept quiet, you are not saying anything. And not only this, there's so many cases where money is there, you have not paid. Someone has kept it in his account or something,
No, that.
interest.
He cannot. No officer can do that.
Nothing.
Officer.
Big amounts, interest.
So they
Nothing.
cannot do that. They cannot touch the money without the approval of institution. Money to the government account, in the government account. Nobody can keep the amount with this group. That cannot be.
And we'll list it after 2 weeks.
But-
You obtain instructions. Hopefully you'll have done. You see, these cases should not come before them.
But that's,
Wasting our time, nothing to adjudicate here.
only apart from the procedural part, I have also no submission. Otherwise, it is, we are in the process of paying. That is what I have submitted.
Okay, right. Mr. Dina, Learned Counsel for the Home and Political Department submits that the matter is before the highest authority. And as and when the same is approved, the proposal will be sent to the Finance Department for approval, for payment of the admitted dues of the petition. He pays for 2 weeks' time to obtain further instructions. This is the matter. Today's what date? 15th.
On
This is the matter of 30th.
Lordship, hearing this matter, Lordship, learned additional advocate general has received some
Huh?
instruction, Lordship, hearing this matter, Lordship, learned additional advocate general will appear, Lordship, Professor Gogoi. Lordship, today he has some difficulty, Lordship, he is on legs in court number 10, Lordship, for some items. Lordship,
AG wants time.
yes, Lordship, can it be on Tuesday, Lordship?
So she make it on Tuesday because we told him we had to do the instruction and the admitted amount for it.
Mr. B. Gogoi.
That's from the Assam House, my lord, this Calcutta. Building was constructed. Chief Minister was supposed to go to inquiry. They found there's no water and sewage system. Immediately they had the military commissioner secretary. And they said that, would you do this thing? to bring let's say connection, all this thing. He did it very shortly. Then he sent a bill, it was sent to the government.
Okay.
So they admitted him out also. That is come out
Lordship,
by
some instructions
Tuesday.
were also been received by Mr. B. Gogol. Yes. So let him be there, Lordship.
Yes, yes.
When?
Mr. B. Gogol, Lordship on Tuesday, Lordship.
Tuesday.
Yes.
On the prayer made on behalf of Mr. B. Gogol, additional AG,
Yes, sir.
Assam, this is the matter on Tuesday. So the matter pertains to not payment of the consultancy fees.
Yes, fine.
Consultancy fees.
Consultancy fees, yes.
The matter pertains to non-payment of the consultancy fees amounting to rupees 16,31,79. This is the matter of Tuesday. Yeah?
It is supposed to be taken up for disposal matter.
Item?
5. It's a contract matter, where the work was awarded to the petitioner matter. The work has been terminated. That has been challenged, madam. Our case is that there is an arbitration clause. Matter should go to the arbitrated forum, madam. There are disputed questions.
Same matter.
Not the same matter, madam.
Huh?
The
Same?
same related matter, Your Honor. Put number 6 is going on.
Madam,
Here is,
regarding the bank guarantee, the bank guarantee was statement, an order of status quo was passed. We have challenged that. That is now going on before the day.
There's a recent Supreme Court judgment on bank guarantee
Yes.
as well.
Even then, madam, bank status quo has been granted, madam. That it should not be.
Who is the counsel? Petitioner's counsel?
BT Das.
We can wait for some time. We'll wait for your.
Yes.
Yes.
Lordship, here in this matter, Lordship, already, Lordship, there has been an order dated 16/8/2024, Lordship. And Lordship, a show cause also been received, Lordship, it's issued by the department, Lordship. So, Lordship, technically, Lordship, the content is complied with, Lordship, because, Lordship, here, the honorable court's direction was there to
Verify and
examine,
pay.
verify and pay. So on examination, it was found that Lordship, amount was around 31 lakhs. Lordship, the 31 lakhs, 26,897.
Where you've got some,
Lordship, actually, Lordship, here in this does not be.
That question,
Lordship,
before the
Huh?
report, my lord, that question was raised before the report, my lord. The result
just
was
let me
that-
see, just let me
Lordship,
see.
here in this matter, Lordship, I have a difficulty in filing the affidavit, Lordship. Because the contemner, Lordship, he is on leave, Lordship, he has gone to Singapore for kidney transplantation. And the in charge, Lordship, he
Well,
cannot.
we'll tell him to come
No,
on a
Lordship,
certain day.
no, Lordship,
Every day,
otherwise,
my lord,
Lordship,
every day, my lord, this is delaying, take
No, Lordship,
they have taken
otherwise,
time,
the-
taken time. my
the
lord, my lord.
direction,
You
Lordship.
filed it, this one, my lord.
Just a minute.
the direction was to examine, yes.
So have you examined it?
Yes, Lordship.
Where?
In fact, a
Lordship,
sitting order has
page-
been passed.
Huh?
Page 9,
Sitting order has been passed.
Page,
like not told you.
page 9?
Page 3, Lordship, is the speaking order. And the amount is at page 9, Lordship.
Page 9.
Yes, Lordship, the top. 58,850 per month has been. So in total,
Page 9.
yes, Lordship.
So that is the admitted amount.
Yes, sir.
58,850.
850 per month, so it comes around 31 lakhs, 26,897.
For how many months?
For Lordship, the- Lordship, from 1/3/2020 to 4/8/2020.
1/3/20
4/8/2024.
4/8/24.
Yes. Is there in the filing of affidavit, my
So
lord?
it comes to how much?
It will be 31,26,897.
31,26,897.
897.
So this is the amount liable to be paid. You
Yes.
pay this amount.
No.
If this is the amount that you have admitted, then you pay this amount. What remains?
No, my lord, what we have to do, let us file a affidavit, because my lord, now as per our, my lord, calculation, we have to deduct something from the petitioner.
You deduct whatever. How
Then
much is
my
to
lord,
be?
actually, we are now, my lord, like, the petitioner is able to pay to us. now.
No, my lord.
As per the terms of the control. In this regard, we have issued.
So where have you stated that? Okay, you make it.
All, yes, day and night.
Okay.
Only thing is, my lord, so far as the superintendent is concerned, my lord, we had a kidney transplant. So he'll be joining only in July. Recently, my lord. We had a PC transfer. It will take some time. He's on leave, my lord, officially on leave. That's why he cannot file the affidavit. If lordship allows, my lord, 10 my lord, his subordinate officer can file it, my lord. That permission is required because
Actually,
it's
my
a
lord,
contempt case.
Actually,
We can file it by tomorrow, my lord. That liberty is given, my lord.
The fact of the case is that, my lord, there is an agreement between the GMC.
Mr. Counsel, this is a contempt,
My lord,
okay? We cannot go beyond what has been
my lord,
directed.
my lord,
Now, the direction is that they should verify and pay.
my lord.
Now they are going to verify and as per what their submission is that on verification, they find that instead of them paying you, you are supposed to pay them. So don't be in a hurry. Let us wait because you see, we cannot decide the correctness of that decision. Just a minute. We cannot decide on the correctness of that decision.
My lord, no, I agree.
That you have got to file a separate writ petition.
My lord, I agree.
So there is no hurry. But only thing is that we
Yeah.
want the affidavit.
Main point is, my lord, there was an agreement, my lord, between him and me.
I'm not going into that. That is not an issue. Right.
Last month maybe given, my lord, they are not filing affidavit since, my lord, on, there is an order, my
You know
lord.
itself, my lord, that liberty.
Look, what I'll do is, instead of that, instead of, why don't you make a, order or something, or some, final report or something
My lord.
with regard to that verification is done, this much has been owed by you to him,
Lordship.
and he owes us this much. On the basis of that, we can dispose it of.
Then, my lord, on Friday next, my lord, that we place it on written instruction, we place, my lord, that possible.
That's all written instruction, so that he can challenge that written
Yes.
instruction. Because affidavit is an affidavit at the end of the day.
Lordship.
You have to give that, calculation in the form of some document. And the basis, you have to give, and in the letter, it can be issued by anybody.
My lord.
You don't need an affidavit. So right. Mr. B. Gogoi, the counsel for the respondent submits that a verification has been done. And though the petitioner is to be paid 31,26,897 for the period from 1/3/2020 to 4/8/2024. The various adjustments have to be made. Full stop. He submits that
My lord,
after
as on date, my lord, 19,43,103. That is the amount that is to be paid by the petitioner to us. Going by
full
the.
stop. He submits that as on date, the petitioner is to pay to the the state government. The state government rupees
19,43,103.
43,103. Then where? That is, you still owe him.
Calculation will be fine.
Then, right, okay, right.
They actually, my
He
lord,
submits that he will give the proper clarification on the issue within a week.
Lordship.
Leave the matter on 23rd, no, 22nd.
My lord.
22nd. Yes,
Open occasion, my lord.
Mr. Gogoi. Yes.
No, it is fine, my lord.
Detail, otherwise I have got my lord.
It is last.
Last time also you had said the same thing.
Yes, my lord.
In April, you had said that. Now it's,
My lord, my phone, my lord, I missed. My lord, can you, I can find it by Pascal. But will take up on Friday in that case. Court, affidavit, I will file.
I haven't admitted.
No, my lord, here the issue is regarding, my lord, that the petitioner was found, though found to be L1, he was not allotted the work. Work has already been allotted at the time of filing of the petition, so there is no stay also. So we'll file it by Monday, I will file.
Okay, right. Mr. P. Gogoi submits that. Affidavit opposition will be filed by Monday.
My lord.
By Monday means 19th, by 19th. Accordingly, leave this matter on 21st.
21st. Yes.
21st. Okay.
The child says Verizon takes.
This is with regard to that SCRT.
Yes, my lord, the instructions were sought for whether who was holding the post on the date DPC was held in 2016, my lord. But time being, my lord, please on legs, yes.
No, okay, this, Mr. Das,
Lordship has already recorded.
no, might have recorded, but I've got to, it's a long report.
Order dated 5/4/2025, my lord.
Huh?
Order dated 5/4/2025. The instruction,
Whether the two statistical assistants in the SCRT, whether they are senior to the petitioner? Are they?
No, man. The dear actual malo, only problem is malo, they are doing service rule malo. In the sphere of the employee, working.
You see, they are all statistical assistants. The
Right.
petitioner is a statistical assistant of Jorhat SCRT, correct?
No,
Yes.
you are not the senior most side.
That is what I'm asking you.
You are not the senior.
No, so,
My
so,
position was in the list, I 16 malo.
there are two other statistical assistants in the SCRT.
in the diet, my lord, they were in diet, they were brought to SCRT later on.
Maybe,
But
They-
in
they-
2016,
no, no, please, do not interrupt. So there are two other SCRT persons. In the SCRT, there are two persons. I think their names also are mentioned.
Krishna
somewhere.
Mazumdar and Suli Dekha.
Yes.
Yeah, man.
So are they senior to the petitioner?
Yes, they are definitely, they are senior malo.
Why?
As per the graduation list malo.
No, not as per the gradation list. I am not on the gradation list. When did they become, when were they appointed as statistical assistants in the SCRT?
I said, Mr. Bora will be my the best person to apply the rules about that malo.
The order of 5/4/25 had categorically requested you.
No, this of standing council malo, SCRT malo, Mr. Bora malo.
Paragraph 22, my lord.
Okay.
Yeah, I'm told that he has already received the instruction malo. Let it come malo.
How long will it take? You have
No,
to-
that instructions will be
He
placed, my lord.
he was almost completed malo. Only the, here there is to pay instruction.
Only if
He
that
can put
instruction
the
is that
accommodated malo.
2016 petitioner was there, my lord, it is the end of the matter.
Without disturbing the response number formula, whether the petition can accommodate the matter. That is the like thinking of people malo.
If it can be, if it cannot be, then
Then, my lord, that instruction, whether in 2016, the DPC meeting, the specific.
you were considered.
Whether it was that, who was the person at that point of time holding the post of statistical, that specifically lordship has put it, that. instruction.
What, just tell me, in 2016, you were considered for this research assistant.
Yes,
Then,
but my senior who was at that, who was promoted, they were not Tirthodeka and Dhuli Mazumdar, some other person.
they were considered along with you.
Yes, lordship specifically wanted, who was the statistical assistant holding the post of the statistical assistant at SCRT Jorhat on 25/2/2016.
Okay.
If that instruction.
Because that person was the one who was considered.
Yes, yes. That is what, if petitioner, if that instruction comes, the petitioner was the only person working in SCRT Jorhat, then it will automatically mean that she is the senior most pilot at present.
Let,
Order of a labor court, madam.
huh?
Order passed by the labor court is after challenge, madam. The three issues basically lordship will require the call upon to answer. Number one is whether an individual dispute which does not fall under the provisions of section 2 capital A of the Industrial Disputes Act, whether it is an industrial dispute. Number two, my lord,
Who is there for the other side?
private respondent has not appeared.
This was issued even paper publication was also there also. So there,
Because now in the meantime, he has retired, madam.
Who has retired?
The workman. He
So
was-
what remains?
He was 49 years of age in 2013. Now he'll be above that. He was in some other employment during the pendency of the case. He has not responded, madam, in spite of notice.
The respondent.
The respondent.
I was also filed also incorporating the notice also. The paper publication, but
He did not respond.
that was kind of.
Huh?
Which association was described of, we have filed on this case also. Which association was
The employees union was struck off, madam, because we have not appeared. But later on, we again filed an application for impleading. That was
Why?
completed. Like it is a necessary party because the union.
They espouse the cause of
they
the
espoused,
workman.
because my case is that it is not a recognized union. It was not, registration was cancelled. And though later on the.
So were they a party there in the tribunal?
Yes,
So
they filed the written statement.
they filed
They
the,
filed.
in the tribunal, where's the award? Let us see the award.
It's not an award, my lord, it's an order, my lord, at page 67.
What are you challenging then?
I am challenging the finding that it is maintainable in law.
Okay, you challenge the finding that it is
Yes.
maintainable.
And the finding operative part, my lord, order starts at 67. The learned labor court discusses everything and the finding is at page 68, last line, my lord.
Just a minute. Page 68,
67, it starts, my lord, finding is at 68.
yes. What is this issue? What is the case about?
The case was that, my lord, the workman was transferred from Guwahati to Shillong. He refused to comply, my lord. He raised an industrial dispute. Then we raised an objection that it is an individual dispute and the union which is espousing is not a valid union.
So he said that he could not be transferred
He could not be.
due to some bylaws or what?
No, my lord. He said it was malafide. That was his case.
Malafide. Malafide, why?
Because there were pending, earlier there were litigations, my lord,
Between,
the party.
so he challenged transfer order dated?
Transfer order is, my lord, 14/3/2009,
14/3/2009, page?
page 22. But the labor court has not entered into the merits. As yet.
What is the reference that had, what was it to decide?
Reference is, my lord. Page 24, my lord.
Yes,
Whether the management of Downtown Hospital is justified in issuing the alleged malafide transfer order against Tilak Doctor. If not, what relief the workman will. As of today, my lord, he will get no relief. Even if
naturally. So it becomes redundant now.
it becomes redundant as of today.
So why don't you go back to the tribunal and decide this? I mean, now there's nothing
Because
left
the,
to
because the
decide.
very issue is that the reference itself is not maintainable. I just point out one thing, my lord.
No, why don't you go there now?
When one legal point was raised by the petitioner regarding maintainability, as per this, as per the documents annexed here, the particular association is not registered at the given point of time. So people go by the Basavara judgment logic, then the finance is not maintainable. It should be registered as per 2QQ logic for the industrial dispute.
There
No,
are various judgments.
no. So did you take up all these points?
Yes, that is-
Acha,
that is the-
after, so it held that it was
Yes,
maintainable.
Lordship will
Okay.
kindly come to page 68.
Their finding is that even unregistered trade union can also
Yes,
approach.
that is the,
That is the finding.
that is-
Otherwise, we.
So basically, you are against the non-registered trade union
No.
espousing the cause of the workman. That's your basic case.
that's the best.
Go by the logic, the principles laid down by Apex Code logic, that is not maintainable.
Okay, let us see page 68.
And the learned labor court discusses everything. I'm not troubling your lordship.
Yeah, no need.
Finding is last line, my lord.
Yes,
I feel the learned advocate for the workman has rightly submitted.
I feel, page 68,
68 last line, my lord.
I feel.
I feel. That
Okay.
is the finding.
Considering the submission.
Considering the submission and also the citation, I feel the learned advocate for the workman has rightly submitted that therefrom the citation, I do not find barring or preventing the unregistered trade union to represent the member. As a result of that, I have found that the plea raised by the management side on maintaining. No reasoning, my lord.
What is the citation?
That is the citation, madam, 2006, 611 SSC page 731. I have got a copy of that.
Now, what does it say? Is it correct?
It says that under 2QQ of the Industrial Disputes Act, under 2QQ of the Industrial Disputes Act, and trade union means a registered trade union.
Or then? So this is completely wrong.
Completely wrong.
He resigned that particular paragraph, otherwise the view is lawsuit opposite view. By relying that particular paragraph, the view is opposite view. I also relying that particular judgment, says that lawsuit is not mistake. This lawsuit.
May I hand over the judgment? Madam?
Paragraph 38 and 39,
37, 38.
38 lawsuit.
The reference, the reference case was filed by whom? Was
Reference was not made by the, it was espoused by the union, ma'am.
by the union?
By the, it is there stated in their WS that on 3/30/2009, they had espoused it. 30th of March 2000.
It says that Tilak Data versus managed, Tilak Data, who's Tilak Data?
He is the workman.
Huh?
He is the workman.
The workman. And where is the management? Management doesn't seem to be here.
The management is there, madam. Lordships kindly sees the order of reference at 23, madam.
23.
In the matter of industrial dispute between the workmen of, the very format says that it has to be espoused because it is workmen. It could not have been workmen of Tilak Dutta, management of so-and-so, and the copy is marked, madam, to the secretary, the general secretary, downtown so-and-so employees union.
Okay. So, what is this? This is the,
That's
which
the judgment, madam.
paragraph?
Well, 37, madam.
That's it, yes.
We shall now advert to the provisions of the Industrial Disputes Act with reference to the registration of a trade unions. Section 2QQ defines trade union, which means a trade union registered under the Trade Unions Act 1926.
Of a registered trade union.
Registered. Specifically defines them. Section 36 of the Industrial Disputes Act says that the workman who is a party to a dispute shall be entitled to be represented in any proceeding under this act by any member of the executive or other office bearer of a registered trade union, of which he is a member, or by any member of the executive or other office bearer of a federation of trade unions to which the trade union referred to in clause A is affiliate. The
Okay,
reputation-
that's all.
That's all.
That's all. So I just heard, Mr.
And they come, madam.
Then they can, counsel for the petition.
I am representing lawsuit 1 and 2. He is the lawsuit presiding officer.
We used to make presiding officers party, but they're on.
Mr. K. Goy appears for
I'm for 1 and 2.
1 and 2. No one appears for respondent number
4 and 5.
5 those.
4 and 5. It is also seen that newspaper publications had been made. In respect of respondent number 5. Further, the Lawazima court order dated 21/8/2024 states that service in respect of the respondent number 5 has been completed. Next para. The matter relates to an order dated
2008, 2013. 20th of
20/08/2013, filed by the Learned Tribunal Guwahati in reference case number 2 of 2011. By which it has been held that an unregistered trade union can represent its member in terms of the judgment of the Supreme Court in the case of B. Srinivasa Reddy versus Karnataka Urban Water Supply and Drainage Board Employees Association and others, reported in 2006, 11 SCC 731.
731 within bracket 2.
731 bracket 2.
Because that page has two judgments.
Okay. Good, sir. The Learned Tribunal, by the impugned order dated 20/08/2013, thus held that the plea made by the writ petitioner on the maintainability of the reference case. No, thus held that the reference case number 2 of 2011 was maintainable. Next paragraph. The petitioner's counsel submits that a perusal of section 2 QQ of the Industrial Disputes Act 1947, hereinafter referred to as the Act, and a reading of the judgment of the Supreme Court in B. Srinivasa Reddy Supla clearly shows that the Learned Tribunal has completely misread the provision of section 2 QQ of the Act. Correct? Next paragraph. Mr. K. Gogoi also submits that the Learned Tribunal has made a mistake in coming to a finding that an unregistered trade union can espouse the cause of its can espouse the cause of a member of the trade union in view of section 2 QQ of the Act and the judgment of the Supreme Court mentioned above. Next paragraph. Section 2 QQ of the Act states as follows. Then you write. Further, section 37. The extract of section 37. No, this is further section 37 of the judgment. Para 37 of the judgment in, what is this? In B. Srinivasa Reddy Supra states as follows. Next. A perusal of the above clearly goes, a perusal of the a perusal of section 22 QQ and the judgment of the Supreme Court clearly goes to show that it is only a registered trade union who can espouse the cause of a member of the trade union. As the, what is the name of the trade union?
Trade union's name, madam. Downtown Employees Union, madam. The Downtown Hospitals Limited Employees Union.
as the Downtown Hospitals
Limited Employees Union.
Limited Employees Union is not a registered trade union. Comma. It could not have espoused the cause of the respondent number four, five. So, sir, as such, the finding of the learned tribunal in the impugned order dated 20/08/2013 is not sustainable. The order dated 28/2013 is accordingly set aside. That's all.
That's all.
The writ petitions accordingly disposed of. Or allowed. Item 5.
This case, my lord, I'll be praying for, my lord. I'll be praying for referring the matter, my lord, the petitioner has taken steps for approaching the
Arbitration.
But there is an order for besides cancellation of the contract, my lord, they have also blacklisted for a period of 2 years. So that has been done without work. So, I will please, my lord, to your lordship, the blacklisting part, your lordship will set aside. They may give over notice and they proceed, but without that.
No, let us see. You see, the issue is whether notice was given to you prior to blacklisting. No, let them say that if they agree to your submission,
Yes.
if on facts it's correct, then no problem. But if facts they dispute that, then I have to hear them on that.
Yes. What my submission will be, my lord, that matter, my lord, we are taking steps, issuing notice for the purpose of arbitration and all. Within the 2-3 days, the notice will be ready. So within 30 days, my lord, I think, hope, my lord, arbitrator will be appointed.
That is a different issue.
My lord, because the issue of, my lord, encashment of bank guarantee, that interim order is there. While in the IA, your lordship has disposed of. So all issues can be taken up before the.
Correct.
That observation.
No, and bank guarantee, so is it an issue here?
Yes. By an IA,
In
I
the
brought
repetition, it was never there.
Okay.
It was brought up by way of an IML. All the.
Anyway, you see, bank guarantee, I don't think we can do anything about it.
No, I'm not saying anything because the order was there and within a period of 30 days, if arbitrator is appointed, my lord, we will take up the issue there. Because normally, my lord, we don't go there, but in this case, because of the.
Is the IA is there?
I have been disposed of. Today
So
matter
all
was-
these issues regarding bank guarantee.
Bank guarantee was-
everything can be decided by the arbitrator.
Correct.
No,
Right,
that
is-
observation with that declaration.
Observation is.
In fact, no, you see, we cannot pass any order with regard to withholding or anything.
Normally, contract cancellation, we go to arbiter, but because of the exceptional circumstances, we came for the court. And because my subcontractor who was doing the work, he has been allotted the work, but a value much higher than the value given to me. So that was the reason.
Maybe because of cost escalation.
No, not because of that. So those issues will be decided by the arbiter.
Cost escalation is there.
But because the last time when the matter came up, a learned friend said, my lord, that I have taken a clue from him that the private.
Okay, now the only issue to be decided here is with regard to the blacklisting portion. That is his case. So now the only issue with regard to that blacklisting is whether he was given prior notice that he would be blacklisted.
Yes.
That's the only thing. So yes, you can make a submission.
Said one thing.
I don't know. Let him obtain. That's the long and short of it.
Along with the cancellation of the contract, they do. They cannot do it. And they can give notice and proceed. That's what she may give.
No, but I have noticed in some of the tender conditions is there that if they are terminated, they will be blacklisted and then debarment for 3 years. That is not permitted. That is not, but that is being done. I've seen 1 or 2 cases.
At least the show cause has to go.
Has to go.
Then going by that.
So whether
erosion
show cause notice
Yes,
has gone?
Page 349.
Show cause 13/11/24. And when was the blacklisting order issued?
12/12/2024.
Okay.
Second last paragraph, my lord, sentence starting with considering the above. You are hereby served this notice to show cause as to why the following actions should not be initiated against so and so. And for default public breach of contractual obligations under 33.3.2. Offload, that is even point number 3. Initiate any other penal action as per tender terms, NRL policies, including without limitation, place your firm on holiday listing for a period of 2 years under crosswords.
This cannot be termed as a matter of show
That is
cause
a different
notice
issue.
or
my lord. His
blacklisting.
submission is that no show cause has been issued. Whether it is a proper show cause or
No, but holiday listing means what?
Holiday listing is they will have to give a show cause matter separately. And in terms of the Supreme Court judgment, will have said, within the judgment time. Where is the judgment?
erosion equipment. 75 Supreme Court.
Otherwise, against the order of cancellation, my lord, I have remedy to go to appeal.
Yes. Gorkha.
Yes. Para 15 and 34. Minus CC 105. If they would have given notice, my lord, then, and the things would have been done after hearing the petition on the ground of, for the purpose of blacklisting, that have an appeal. Fifteen, 16 onwards. All these case laws have been.
No. Point me to the right one. Others have to read everything.
Para 16, my lord, you can see it is a common case of the parties that the blacklisting has to be preceded by a show cause notice. Law in this regard is firmly grounded and does not even demand much amplification. The necessity of compliance with the principles of mutual justice by giving the opportunity to the person against whom action of blacklisting is sought to be taken as.
No, this is not the issue.
Second is, my lord, ultimately paragraph 34.
No. You're not hitting the,
Para 27.
you have to come to page 21, para 21,
21 and 27 also.
contents of the show cause notice.
Pertains to the requirement of stating the action which is proposed to be taken. The fundamental purpose behind the.
You see, it says here, have you got that Gorkha? Have you got this case? Gorkha Security Services,
No.
2014, 9 SEC.
I have it. Para 21.
Para 21 basically. 21 is the content.
So he must be aware of what is against him. my lord.
Yes.
So Lordship peruses not only this order, this show cause, my lord, this is the third show cause. He is fully aware of what are the allegations against. He has failed to perform the work.
No. You have to give a separate show cause for blacklisting because it amounts to civil death.
Yes.
You have to give him all the, it's like a memorandum of charge. You have to give everything. You see, it says here, the central issue, however, pertains to the requirement of stating the action which is proposed to be taken. The fundamental purpose behind serving of show cause is to make the noticee understand the precise case
Precise.
set up against him which he has to meet. This would require the statement of imputation, detailing out the alleged breaches and defaults he has committed so that he gets an opportunity to rebut the same. Is the nature of action which is proposed to be taken for such a breach.
paragraph 27 also.
Yes, sir. You see at para 22 also. The show cause notice should meet the following two requirements. The materials grounds to be stated, which according to the department necessitates an action. Particular penalty action which is proposed to be taken. We may hasten to add that even if it is not specifically mentioned in the show cause notice, but it can clearly and safely be discerned from the reading thereof, that would be sufficient to meet this requirement.
So, my lord, I'll draw your lordship to the show cause notices given prior to dismissal.
Is it in the prior notices? Did you say that you were going to blacklist him?
But the defects were pointed out.
No,
And
no, defects, you see.
lordship will kindly bear with me for a moment. Page 344. Your lordship.
Just a minute, let me read 27 first.
It was incumbent on the part of the Department of State in the show cause notice that the competent authority intended to impose such a penalty of blacklisting so as to provide adequate and meaningful opportunity to the appellant to show cause against the son. However, we may add that even if it is not mentioned specifically, but from the reading of the show cause notice, it can be clearly inferred that such an action was proposed that would fulfill this requirement. In the present case, however, reading the show cause notice does not suggest that notice could find out that such an action could also be taken.
You see, this page 349,
Yes.
it can be inferred that he's going to be blacklisted because he's going to be put in the holiday list for 2 years. Holiday list basically amounts to being blacklisted.
Yes.
But only thing is, the requirement of putting the particular imputations on the basis of which you're going to put him in the holiday list, those have to be specific and those have to be stated.
It is
Yes.
specific. Madam.
Where? Come to
10,
349,
10-9, it is specific. It is delay, madam. The only ground is delay.
only one delay.
Only ground is delay, madam. The original work time was.
Let us see what has
Yes.
been stated there.
Let us read, madam, 344, madam.
340, no, wait. 344,
Because this.
wait. You see, 344, what have you said out it? That he will be put on the holiday list, have you said that?
In 344, we have not said.
Then you see,
But
344 is of 10/9/2024.
10-9, 2020.
You have put him to notice with regard to blacklisting only on
13/11.
13/11/2024. So those issues, those other show cause notices that have been issued prior to this date, unless you have mentioned
Yes, it is
blacklisting or holiday listing,
my lord,
these
it
cannot be
is-
taken into account.
In 13-11, my lord,
Ah.
this 10-9 is specifically referred to.
No. Maybe referred to, no, but then it will not do.
Because the issue is that.
You can
Aware,
always,
madam.
you can always give him another show cause.
That can be done. madam.
You can give another show cause. There's no bar. You can give another show cause, there's no bar, but this will not suffice. At least in my book.
But the only ground, if your lordship reads 10-9, my lord.
Let us see, no, 10/9, I'm not going to 10/9. If you had made a mention of holiday listing in 10/9, then it's
So
okay.
in 10-9, there is.
Then no, then it is like saying that the punishment, now you see the punishment, proposed punishment has been made only in November. So at the time of 10/9, there was no proposed punishment.
Just give me a moment, madam. Let me see clause 30.3, madam. What does it say?
The final show cause was given on page 348. And we have given reply. 348, similar, same, my lord, I think. Starts from 349. Same notice, it is dated 13/11/24. And we have given a detailed reply at 354. We have not considered all this. Suddenly they have just come in. and given their contract to the person who has worked with us.
Acha, let us see 349, the contents of 349
Don't
are
talk
enough,
about
to blacklist you.
349.
Let
Yes,
us see if 340, because 349 has said that they can initiate any other penal action as per tender terms, including without limitation, place your firm on holiday listing for a period of 2 years.
Lordship, you can see that judgment which your lordship has gone through, it has been meaningful. Show cause notice has to be precise. Then
Then,
why you should not be blacklisted for all these things? And we had given a reply.
no, I'm not going into the merits of whether your reply is correct or that is a different thing.
But there,
I'm only going into the
Give us
issue of,
what is the meaning of opportunity of hearing? Opportunity of hearing that you give a notice, then you hear us, then decide.
correct.
Now only just giving a notice, then terminate the contract.
No, let us see.
Page 349.
So 349 is, you have been given, you have been told
Yeah.
that to resume the reaming activity on or before 4/11/24. So. Let us see the termination order.
Termination order, your lordship will get it at page 360. 360.
this is in reference to the above mentioned tender. You are offered the LOA, the PO, the EIL notices, the first show cause notice, the final EIL notice, the VAPL letter, the second show cause notice, the VAPL reply, and all related communications with your firm in this regard. Please note that you have failed to honor the terms of the LOA and PO by failing to complete the awarded job within the contractual completion period of 20 months from the date of LOA, as stipulated under clause 1 of the LOA, even after repeated reminders. Furthermore, you have also failed to resume the reaming activity on or before 4/11/24, as was directed through the final EIL notice. Moreover, you have also failed to show adequate causes as to why the LOA PO should not be terminated, as your firm should not be put on the holiday list of NRL. In view of the above, NRL has decided to terminate the LOA and PO placed on your firm under clause 30.3 of the special conditions of contract of the tender, and undertake the job at your risk and cost as provided in the aforementioned clause of the tender. In this regard, you are categorically directed not to initiate any action under the LOA, and in case any such action is initiated by you, the same shall be denied at the sole discretion of NRL. Furthermore, your firm has been placed under holiday list for a period of 2 years for with effect from 12th.
Let us see his reply.
Lordship will find the reply at page 351. Also at 354, 351 is the email and 354 is the letter. 354, madam. We acknowledge, in reference to your letter dated 13/11, we acknowledge your concern for the delay in the progress of the project as per your expectations. As stated by your good offices that we are not meeting our contractual obligations and are hence causing a delay. In this context, we would like to state and bring to your notice that we have not stopped any activity even when the sites were flooded, whose impact we had to overcome from the end of June to mid of October 24. The sites, especially the pipe site, had no access till the end of September 2024. And in spite of that, we continued.
So basically you have given your
He
answer.
has given his answer.
You have
No one
given your
said
answer.
that he's not aware of what is against him.
And so everything has been there.
These are all force majeure clause.
Whatever, no, I'm not going into whether
No specific notice.
no, your issue was, you see, if I remember correctly, you started your submission by saying that you're going to go to arbitration. Let the arbitrator decide the issue of termination and also the issue with regard to the bank guarantee, invocation of the bank guarantee. Your third submission was that the issue with regard to blacklisting has been done without any notice being issued to you. Now I find 349, that notice has been issued to you.
Not-
And you have answered to that notice.
Not specifically as regard whether.
Why not? It is, holiday listing means what? Holiday listing means blacklisting.
And that is there, but specifically, according to me, my lord, to my submission is the that specific notice separately has to be given.
No,
That,
no, where does it? fit?
because my lord, meaning is not clear. This notice is specifically why it will not be cancelled.
No, no, it
Why
says
it will
there.
not be
It-
cancelled.
it-
Your
it-
lordship
no,
will kindly say ultimately, P49, your lordship will kindly say P45 notice, considering the above, third paragraph.
Yeah.
Considering the above, hereby serve this notice to show cause as to why the following action should not be initiated against so and so for default breach of contract obligations under clause so and so of the special conditions of contract, general purchase conditions to the contract, offload, same thing, my lord. Offload, forfeit the security, initiate any other penal action, they can initiate other penal action as per tender terms, NRL policies, including without limitation place your firm, they can initiate all these things. But regarding, my lord.
Okay, initiate any other penal
Yes,
action.
they can initiate all these things.
Ah, yes, there's another, yes. There is this use of the word initiate.
Otherwise, my lord, otherwise what they have done, your lordship.
Initiate penal action.
Yes, this is.
Initiate
without
penal
limitation.
action as per term slash NRL policies, including
Without limitation.
without limiting, place your firm on
Holiday
so
list.
including.
Yeah.
So you initiate. He's quite correct that too. That word is the initiate.
Why I have said, my
You have
lord,
not initiated.
all these explanations are under force majeure, my lord. Force
I'm
majeure.
not on that.
My lord,
That
yes,
is something
yes,
beyond.
go to the article.
Now that is something else. You can initiate.
Lordship will give us that liberty.
And it is already there. He's also saying that he's also saying that it has not been initiated against. That's up to you. Why should I say that you should do it?
No, no. Lordship will not say that we'll do it. Lordship will at
Why
least.
should I give you liberty? Liberty is already granted to you by the contract agreement. Okay, right. Oh, yeah, lucky, just in time. Heard Mr. B.D. Das, senior counsel for the petitioner, assisted by Mr. J. Lotha. I've got a friend, David Lotha. He's in, what is that near Kohima, that your town? Wokha. He's into this, he's a naturalist, he's into birds and whatnot. Okay. Nagaland, Amur falcon and all. Yes, okay. Heard Mr. N. Deka, learned counsel for the respondent number 1.
1 to 5.
1 to 5. Mr. Sharma, you're there?
7.
Mr. R.P. Sharma appears for respondent number 7. Learned senior counsel appears for respondent number 7, assisted by Ms. A. Deka. Anybody else? Mr. R.K.D. Chaudhary, learned deputy SGI, appears for respondent number 6, and Mr. A. Ganguly appears for respondent number 8. So you have nothing to say. It's okay. I'm not going into that. I'm just going into this issue, right? It's right. The petitioner's case is that the petitioner was issued contract work for installation of pipeline by horizontal directional drilling. The period of contract was for 20 months. As the contract work could not be completed within the stipulated time period, the petitioner was issued 3 notices. 3 notices prior to cancellation of the contract, prior to termination of the contract work. By termination order dated
12/12/2024.
12/12/2020. The subsequent to the above, subsequent to the termination of the petitioner's contract work, of NIT was issued for concluding the balance work, balance contract work, which was awarded to the respondent number 7. Pusta. Next para. The petitioner has put to challenge the termination order dated 12/12/2024 and the attempt by the and the process undertaken by the respondents number 1 to 5 for invocation of the bank guarantee.
Bank guarantee was not put to challenge in the writ petition.
Oh, it's not here?
No.
Okay, don't say
He
that.
has challenged the award in
they
favor of
said-
respondent.
Yeah, the termination also you have challenged?
Yes, termination.
Challenge the termination order, termination order 12/12/2024 and the award of the balance contract work to the respondent number 7. First stop, next para.
And holiday listing. Holiday listing part of the termination.
First stop. The petitioner's counsel submits, this para, petitioner's counsel submits that the petitioner has also been put on the holiday list by termination order dated 12/2024 without initiating any process for blacklisting the petitioner by issuing a show cause notice for blacklisting the petition. By issuing a separate show cause notice for blacklisting the petition. Next paragraph. The petitioner's counsel further submits that in view of there being an arbitration clause in the contract agreement executed between the parties, which is that clause
Clause 8.7.2,
8.7.2,
page 222.
222.
Arbitration clause. Page 222.
Right. Now, the petitioner seeks to invoke the arbitration clause for settlement of the dispute, settlement of the issue regarding termination, termination of his contract.
Whole issue before the bid court, whatever issues are there.
For settlement of his, dispute, for settlement of all his disputes between the parties, first stop. However, in respect of the petitioner being put on the holiday list / blacklisting, in terms of the termination order dated 12/12/2024, the petitioner submits that unless and until a separate show cause notice has been issued to the petitioner by putting the petitioner to notice with regard to the exact case set up against him, detailing out the alleged breaches and defaults and the statements of imputation, allowing him to rebut the same. The petitioner cannot be blacklisted. In this respect, he has relied upon the judgment of the Supreme Court in the case of Gorkha Security Services versus Government (NCT) of Delhi (close) and others, reported in 2014 9 SCC 105. Next. Accordingly, now the petitioner's counsel thus submits that the termination order dated 12/12/2024 should be set aside insofar as it has put the petitioner in the holiday list. Next paragraph. The learned counsels for respondents number 1 to 5 submits what? You admit
No,
that,
that he had due notice of the allegations against
okay, submits that the petitioner had been given due notice that he would be put on the holiday list in terms of the show cause notice dated 13/11/2024.
as well as the other previous notices.
Further, further, the other notices issued prior to. No, further the other notices dated, further show cause notices dated
Dated 10/9/24,
10/9/24 and
14/10, not 14/10, madam. 6/5/24,
6/5, 14/10 and 6/5/24.
10/9, madam, not 14/10.
10/9/24 and
6/5/24,
6/5/24.
as well as others, madam.
Then from 3 you've gone to more than 3.
Is more than 3, madam.
Earlier you said 3.
It is more than 3.
Please be careful of the words you use.
1, 2, 3, 4, 5, 6 notices. madam.
Okay, just say, further, the petitioner has been issued 6 other show cause notices prior to the show cause notice dated 13/11/2020.
No, including the prior to 5, including 13/11, it is 6.
Okay, then 4 other notices. Huh?
5 other notices.
5 other notices, no, 5 other notices. Prior to the show cause notice dated 13/11/2024. Stating the specific instances of breaches and defaults on the part of the petitioner while implementing the contract, while doing the contract work. As such, the petitioner was well aware of the case set up against him by the petitioner, by the respondents. The petitioner having also made replies to the show cause notices. It cannot be said that the petitioner was not aware of the imputations made against him and for which due opportunity for rebuttal had been given. He accordingly submits that there is no requirement of having for initiating a fresh initiating a fresh show cause notice for blacklisting the petition. Correct?
Holiday listing, madam.
Same thing. Blacklisting, holiday listing. What is the difference?
No, madam. Nowadays it is specific instructions from the government that not to use the word blacklisting, madam.
Okay, you say holiday listing / blacklisting.
If the holiday word is always better. He's put on holiday, madam. He's not allowed to work.
You see, the problem is that we have been brought up on the words blacklisting. Very change to change your mind. You see, it's like a leopard cannot change its
Change the
spots.
spots.
Yeah. Anyway, and you see the judgments of the Supreme Court that we refer to all talk of blacklisting.
Yes.
So anyway, just tell me one thing, in the show cause notices prior to 13/11/24, is there any mention of holiday listing? None. None, no? Yes, right. So,
Can I just confirm, madam? Just
yes, you please
It is-
confirm,
it is-
please,
it is
please
not there.
confirm, please
Can I
confirm.
just confirm, madam?
If you don't confirm, it will be
Keep it different.
difficult for all of us.
Yes, madam.
We are making wrong, so you are making wrong submissions, I am making wrong observations. Mr. Sharma, you want to make any submission? No, no need. That you are going to complete 90% and all, no need.
Just in one, my lord, it is there, madam. This is not HP. In 10:9, there is a what, like I said.
10-9. 10-9 is a page.
10:9 is at page 344, my lord. Although the word use this band. Meaning is the same. 347.
347. 347. 347.
Since the above facts reflects, second paragraph,
Yes.
default oblique breach of contractual obligations. You are hereby required to show cause in writing within 15 calendar days from the date hereof as to why the contract should not be terminated and business dealings with you should not be suspended or be banned. But what is the same?
Should not be terminated.
And business dealings with you be suspended or be banned.
Business dealings with you suspended.
Oblique
But
ban.
then you see, business dealings, it cannot be in perpetuity.
It cannot be in perpetuity, it has to be.
For how many years? You have got to put him to notice as to how many years.
That is done in the subsequent notice, 1311.
Because their Supreme Court judgment that it cannot be done in perpetuity.
It cannot be done in perpetuity. That is a settled
So,
purpose.
so will this amount to notice?
It will amount, the lordship will record my submission that it will amount to. Because everything has to be read together.
He's saving himself.
Naturally. But then it causes more problems for me. I've got to clarify everything. Right. Next para. Mr. N. Data submits that. In the show cause notice dated 10/9/2024. The respondents had also informed the petitioner that no, was also, no, the petitioner also put to notice that not only would his contract be terminated due to the default and breaches on the part of the petitioner in his contract work, but that he would also be, but that his business dealings would also be suspended / banned. Suspended. Business dealings suspended.
Banned.
Huh? Yes. Now, business dealings would be suspended back. Is it pertaining to this contract only or to some other contract?
No, if it is, he is placed in the holiday list, my lord, he'll not be able
No,
to.
no, I'm talking about 347, page 347.
347 is regarding this contract, not only this contract. If it is
No, no,
banned, my lord, he'll be banned. Business dealings, my lord, does not only with particular.
No, but don't you have to clarify that the business dealings with any future contracts? Or what about existing contracts? Supposing he has some other existing
It says,
contract.
my lord, I'm thankful, my friend. It says we are required to show cause within 15 days as to why the contract should not be terminated. And that's separate. And business dealings with you should not be suspended.
Okay, future business.
This is the future business.
Okay. Good stuff.
Thereafter, again, the 349 page.
349 says again initiating. And then, right. He accordingly submits that the petitioner's prayer for setting aside the impugned termination order dated 12/12/2023 in relation to the initiation of the action for placing the petitioner on holiday listing for a period of 2 years. What do I say? How does it start? No, not for initiating, for setting aside. Instead of initiating, it's for setting aside. I mean, holiday listing, blacklisting should not be allowed. I have heard the learned counsel for the parties. As the, no, as can be seen from the submissions made by the counsels for the party. The only issue to be decided in the present case is whether the putting of the petitioner under holiday listing for a period of 2 years by the order dated 12/12/2024 had been done after issuance of a show cause notice by the respondents, putting the petitioner on notice that he would be blacklisted, that he would be put on holiday listing / blacklisted. Next paragraph. Out of the 6 show cause notices, 6, Mr. Degas, out of the 6 show cause notices that had been issued by the state by the respondents number 1 to 5 to the petitioner with regard to the default / breaches of the petitioner's contractual obligation comma, the show cause notice dated 10/9/2024 has stated that the petitioner was required to show cause in writing was required to show cause with respect to the default / breaches made by him in respect of his contractual agreement obligations. And no, so as to put him to notice as to why the contract should not be terminated and business dealings with him should not be suspended / banned. A reading of the the relevant portion of the show cause notice dated 10/9/2024 is reproduced herein below as follows, page 347 in red, okay? Next paragraph. A perusal of the above shows that the petitioner has been put to notice as to why his business dealings with the respondent should not be suspended / banned. Where is the clause regarding holiday listing?
There is no clause, madam. There is a separate policy.
Separate policy.
Separate another policy.
That is not in the, that is not,
That is not part.
full stop.
Page 161.
161.
2.14.
Okay. This is,
Guidelines.
this is,
Guidelines are not here.
huh?
Guidelines, it says that guidelines and procedures for holiday listing as adopted by an shall be applicable. Those guidelines are not part of the record. Just let me check, madam, if I have a soft copy with me.
This 161 is from where?
Is the part of the tender,
It's part of the tender,
part of the tender.
right? There is no provision, there is no clause in the tender notice, in the tender document, or the agreement executed between the parties with regard to suspending. Is there any clause for suspending and banning? Suspending and or banning?
It's already listed on tender.
A contractor. Though clause 3.14 of the general conditions of contract, like a GCC, provides for a holiday listing of a contractor, which states as follows, page 161. Okay. Page 161. Where is the guidelines and procedure in our
Guidelines is there separately. It doesn't say when specifically the notice is to be given.
No, I want to know.
Please go ahead. I've checked, there is a provision for filing appeal.
Let me see.
But there is a clause. The contract. And I'll get a copy of the policy.
I'm writing the judgment now.
I'll get a copy.
I won't remember.
And should I?
Then
give
Lordship
a-
will take it up at 2 minutes.
No.
Yeah, Parliament. Okay.
give them a-
Next para. Tata, next para. The last so-called notice dated 13/11/24 issued by the respondents to the petition.
It is there, my lord, page 179 and 180, my lord.
Has put the petitioner to notice that his contract was liable to be terminated. And the following actions now, and as to why the following actions should not be initiated against him under clause 30.3.2 of the special conditions of contract / general purchase conditions to the tender, which are as follows, which are as follows, page 349 from here to here. Okay, which part is it?
The blacklisting part, my lord. Page 179 and 180.
No, out here. The holiday listing. Suspension, blacklisting. Same as debarment. Banning of suspension, okay. Then come back to the other one, come back to the earlier one. What is the earlier one? Huh? No, before that. We have not completed it, no? Oh, you have taken next pair after that. The guidelines for putting a no, this is the policy slash guidelines for putting a contractor for holiday listing slash holiday listing provides that the term holiday listing, comma, banning of firm, comma, suspension, comma, blacklisting, etc., convey the same meaning as of debarment. Okay. Next. Keeping the above in view, it appears, no, it can be said that the show cause notice dated 10/9/2024 had put the petitioner to notice with regard to the intention of the state respondents to put the petition on holiday listing. The problem, however, arises with the subsequent and last show cause notice dated 13/11/2024. When you read 13/11/2024, what is it? Next, what did I say? I gave you the detail. Sir. The use of the words in clause 3, Roman 3 small, inverted commas, initiate any other penal action indicates that an action indicates that the other penal action regarding putting a firm on a holiday listing for a period of 2 years can be done. No, has not been done, has not been done. So stop. Next para. In the case of Gorkha Security Services. No need, I'll just go on that only, no need of this Gorkha. Okay, I'll pass the order. Let me decide how it should go. Basically, I'm going to hold that it has not been initiated. Yes. So basically, you can initiate fresh, but it has not been initiated because of the use of this one. I just said one thing. The respondents cannot be allowed to blow hot and cold. In the matter of blacklisting of firm slash petitioner. Keeping in view the fact that the blacklisting of a firm amounts to a civil debt, as has been referred to, as has been held by the Supreme Court in various judgments. Though the show cause notice dated 13/11, no, not 13, show cause notice
10/9.
dated 10/9/2024 indicates that the petitioner has been put to notice regarding the blacklisting, regarding the proposed blacklisting of his firm. The subsequent and last notice dated 13/12/2024 has clearly stated that any other penal action may be initiated, including placing the petitioner firm on holiday listing for a period of 2 years. Next paragraph. In the case of so and so, the Supreme Court has held that one should not appropriate and reprobate so and so. I'll put that. And so something to that effect. Not say we disposed of.
Issues before the petition, we may be given liberty to approach the arbitrator.
No, yes, no, you go to the arbitrator. Yeah, I'm not going into that. You have already taken a decision. I'm only going into the issue of this.
But your lordship will record that.
All issues will be,
What?
all issues will be open before the arbitrator. Pray that lordship may kindly.
Okay, you want that? Okay, just right. All other issues with regard to the termination of the contract and the consequential allocation of the balance contract work to the respondent number 7 shall be
Settled by the article.
shall be settled by the shall be open. Shall be
Shall remain open.
shall remain open for the arbitrator to decide.
Apply. My London 20 same, my, what may record his name, madam.
Why?
Will watch it. Watch it. Jesus.
Okay, whose name should I record?
His name.
Not your name.
My name will be there, madam, along with me, madam.
Okay. Instructions, proper instructions are needed. Okay, what is your name?
Amish girl.
Amish Garg, and Amish Garg. N Deka and Amish Garg for response number 1 to 5.
Apply. Acha.
8 and 9. What? 8 and 9.
Method,
Ah.
item number 8 to 9. Madam, I have been told that Mr. S. Deka is there in port number 17 from 10:30. And it
So?
will take the whole day.
Why? It won't take a whole day. Why? Whole day. What will I do after this? I think we've got only that, no? One more is there. Huh? There's hardly anything to decide now.
Yes, my lord, that's the instruction I am saying. Only he can also produce the instructions, my lord.
I asked him if he wants to see.
We will keep, what item is he doing? What is your item in court number 17? Oh, 142,
1 to 42.
1 to 42. What is this bench matter? Huh? BTC? Which court is that?
Justice Prabhudev Chowdhury.
Editor. What, with regard to contractual dues or what? In fact, property, okay. Whole day is going to take.
As per our instructions, my lord.
As per our administration, madam.
It's going to continue after at 2.
Is he one of the lead lawyers there? We'll see. We'll wait for him. It might end also because we've got one more matter.
Lordship, lord.
It's a problem, we come, we read also, we get tired of reading also. Same case over and over again. Last time also you all had adjourned.
Last time.
At too much.
Again, the case of blacklisting. What's it card that method on 6th of this month?
Just, I don't remember.
Order with the 6th of,
Just let me see, huh?
there are basically two grounds.
Just, Yes. So basically, according to the department, blacklisting has been, the period has expired.
The initially when filing of this petition, we also taken the ground that there is no notice,
There is no,
no notice.
how does it matter? If the period has expired,
That is why, that is under change circumstance, the period is over. That is why this.
so what remains?
Lordship, as per the last order, my colleague has already submitted one guideline before your lordship. The guideline for registration and renewal of contractors of water resource department.
Ah.
Lordship, various department has got various guidelines
Correct,
regarding the renewal and registration of the contractors. If lordship may kindly peruse J. Section J.
So no, so the thing is, here,
Blacklisting of contractors.
his case is on two grounds.
Yes.
One is on blacklisting,
Ah.
one is on renewal.
When Lordship, regarding the blacklisting, in section, I,
Yes.
it's once the blacklisting order is issued,
Ah.
it shall be revoked ordinarily unless one on review in later date, the chief engineer.
Where are you reading?
Lordship,
Where are you reading? Which page? Where?
this is the last page, Lordship,
Last page of?
this instruction, Lordship.
That is instruction.
L, Lordship.
Guidelines.
L, yeah, guideline, L.
L, okay, yes.
Once the blacklisting order is issued, it shall not be revoked ordinarily unless one, on review in later date, the chief engineer is of the opinion that there is sufficient justification to revoke the order of blacklisting, or in respect of the same offence, the accused has been honorably acquitted by the court of law. Since that.
So according to you,
Lordship,
blacklisting can be done for perpetuity.
no, not that. Means what my prayer is, let this matter be remanded back to the department and chief engineer, let him take the call.
No, you tell me one thing. Let us see the impugned orders. One is at page 39.
Page 39, 40 is the.
39 is 13/5/22.
That was superseded by order dated page, next page number, 18/5/2020. Page 40, last line, that's, this supersedes the earlier order number so and so dated 13/5. So this is the final order.
How can it be done in perpetuity? Can a blacklisting order be issued in perpetuity?
This one is based on the FIR. FIR has also been registered against the petitioner lordship. And now the trial is going on in these two matters, lordship. My landed senior, no.
There is a
No, you
stay-
see,
there is a stay by this another.
no, that is a different issue. The issue is, what is the blacklisting scheme or guideline followed by the state of Assam?
It is at page 52.
Which every department has got their own.
So what is your
Our
procedure?
procedure is lordship, that is in this one, J, blacklisting of contractors by chief engineer of the department.
This is by the chief engineer.
The rule is at page 52, madam. General Financial Rules 2017. Relevant portion is left
A
at
contract-
page 54.
Yes,
Rule 151. What
yes.
are the circumstances, my lord? A bidder shall be debarred if he has been convicted of an offence. Convicted. You will have to be convicted. Mayor, FIR will not do.
Yes.
Under Prevention of Corruption Act, the IPC and lordship may skip this Roman 3, my lord, last. The procuring entity may debar a bidder or any other successors from participating in any procurement process undertaken by it for a period not exceeding 2 years.
Correct.
That is also,
This is by the Ministry of Finance.
Yes, but the
This is
department.
what about the state government, Mr.
That is
Kaushal?
what lordship, every department of the state government has got their own rules, lordship. Accordingly, water resource department has framed their guideline.
which is before your lordship. And the guidelines. If lordship turns to J, point J, it is written that blacklisting of contractors by the chief engineer of the department. A contractor will be blacklisted on the following grounds. One, in the event of any adverse police report against him, or in the event of any FIR is filed against the contractor. Number 1 point, lordship. That FIR is filed against him, and because of that only he has been blacklisted, lordship.
I've got it.
Yes, lordship.
So,
This is
but then it cannot be forever.
no.
You see, Mr. Counsel, this is also wrong because FIR is only FIR. You see, in Indian law, a person is presumed innocent until proven guilty.
That is why it is convicted.
Huh?
That is why the word
That is why the word
Convicted
convicted. How
for
can it be? How
Unless
can this
it is
guideline hold good?
No, he has not been pleaded guilty till now, but
Naturally, that's why if he's, why are you presuming he's guilty?
no, we are not presuming him guilty, lordship. We are not presuming him guilty,
Ah.
lordship. Only because the FIR is being filed against him, lordship. On the
No, but
course of,
Mr. Counsel, you see. You see, the thing is that you cannot blacklist a person in perpetuity. It's a civil death. You cannot. Show me the law which allows you to do so. Have you got the Supreme Court judgment?
Yes,
Yes, give me that.
and so far as notice is concerned, your lordship judgments are there.
Give me, I don't know. No notice was issued to you.
No notice was issued.
No notice.
No notice.
Yes, Mr. Counsel, no notice was issued.
regarding that, I have to take a better because I am not aware whether notice.
What do you
because
mean?
the
You have got to
order
take
is
suggest-
there.
Your affidavits are here.
Yes, lordship.
Then,
Affidavits are here.
what does the affidavit say? You cannot go beyond your affidavit.
Yes, lordship.
Paragraph. First paragraph. Oh, sorry, please, 125. However, on telephonic request, page 124 now.
Which portion? Top,
Top, the top
which
line.
paragraph?
However,
Okay.
However, on telephonic request, the petitioner a copy of the aforesaid orders was sent to this email. The
Copy of what orders? Copy of this?
Then imperial orders were not. Not to speak about.
Not to speak of the.
And nowadays, Malad, it is from 2016, everything is on Malad mail, electronic. And so far as Malad that rule is concerned, Malad lordship, the other day Malad asked me whether they follow the rules or not.
Follow which rules?
This general finance rules.
Ministry of Finance.
Yes, Malad. That 148, page 148, Malad. Petitioner submitted a Malad RTI RTI application, Malad. Annexure 24, page
Yes.
148. Question number 15, Malad.
There is no question number 50. What is this? This is a page 140.
Page 140.
It's a Gmail. It's a mail.
148, Malad. Page Annexure 24.
140A, capital A.
1448, Malad.
8. No, I've got it. This 148 is this one.
Annex. Affidavit in reply, Malad.
Affidavit in reply.
Affidavit in reply, first annexure, Malad. So RTA application by the petitioner, Malad, dated 16/12/2022. Question number 15, he put, Malad,
Just a minute. Affidavit in reply. Filed by petitioner.
filed by the petitioner, Malad. It was filed on 27/2/2022.
Yes, para.
Para 16, Malad. Para 15, Malad. Whether Assam Public
Procurement Act 2017 and Applicable Procurement Rules have come into force and enforced by the Water Resource Department. If so, from which date? Lordship will find the reply.
No, no, where are you reading?
Question number.
Affidavit in reply, which page, which para?
No, it is, I have
Annexure.
Annex, first annexure.
Yes, yes,
It is annexure 24.
yes,
Question number 15, member, 1 5.
yes.
He asks whether this 2017 and 2020 rules have been followed and from
Yes.
which date. Their reply, my lord. Lordship will find in the last page, my lord. The reply of page 24, they say, yes, from September 2021. So they follow. In fact, the affidavit in opposition, they deny.
No, no, wait. The last page is what? This annexure 26.
No, my lord, before that, my lord.
Okay, yes. Okay, okay, page 164. Yes,
In fact, in the affidavit in opposition, they indicated that they don't follow this rules. But in the reply, Lordship has seen.
huh? What did you say?
In affidavit in opposition, they deny. About that, we do not know about these rules. But in the RTI, it came to light, that they
No,
know.
but they're denying now the authenticity of the document has to be now approved. If they deny that, Mr. Council, they are denying, it could be, you could have made it up.
No, it
You see, when they deny a document, they've got a right to deny a document.
no. So far as enforcement of the rule.
You see,
They say that we do not know anything about the rule, but the reply, in reply, I've annexed that. RTI.
that doesn't cut any ice.
Anyway, 2017 rule is binding on the department.
2017.
Yeah, that general financial rules,
Why is it binding?
because it is a government department member.
No, no, that is the ministry, Mr. Council.
Lots of.
That is the ministry, finance ministry. Just because the central government has made some guidelines,
Lots of.
it doesn't mean that it is binding on the state government. You see, look at the CCS pension rules, central CCS pension rules. That is, you have made your own rules in Assam. You've got the 1969 pension rule. How can you say that all central rules are applicable to the state of Assam?
So far as perpetuating party is concerned, madam,
Huh?
perpetuating party is concerned, that cannot be for forever. No. That is what.
Correct.
Honorable.
It cannot be forever.
Yes, Lordship. So my limited query is that let the matter be remand back to the.
No, why should we? You are not. Why should we give you a handle?
So that he can take the call as per.
No, no, you tell me one thing. Was any notice issued to the petitioner prior to issuance of the blacklisting order?
That I have taken.
No instruction required. If your affidavit does not say so, I'm not going to ask. This is a pending matter from 2022.
Yeah.
And 2 years have passed. No issue.
I think probably.
No. I'm allowing the writ petition. No case. Yes, where does it say that perpetuating? Don't give me judgment. Just tell me where has it been said that it cannot be done in perpetuity.
That is BC Biani projects limited number. Short. Envelope.
Yes. Para?
Third parameter. Last line, the order of blacklisting is for an indefinite period. The finding of the court is null. Since the appellate, the next is number.
Huh?
Second paragraph, next page, second
Yes.
paragraph. Since the applicant is blacklisted by an order dated so and so, since there has been more than 3 years have gone by during the period, the appellant has suffered.
No, this. You see, there is an order, say that it cannot be in perpetuity, can it be in perpetuity?
Yes, but the period of blacklisting already undergone by the applicant is sufficient to meet the ends of justice.
That is a different issue.
There's another judgment.
Mr. Counsel, is there a judgment? Please look this side. Is there a judgment by the Supreme Court or by any court which says that blacklisting cannot be done in perpetuity? Do you have a judgment to that effect?
Yes. Is Fate India Pharmaceuticals, that is also the same line.
Huh? What?
Fate India Pharmaceuticals Limited versus State of UP. Equivalent is 2020 Supreme Court 5753. 5753. AIR 2020 Supreme Court 5753. I have given a copy.
Huh?
I have given a copy.
Yeah, 2020, yes, 5753, yes, it is with me. It is with me. Yes, which paragraph?
Paragraph 13, my lord. In view of the aforesaid conclusion, there may have been no need to go into the question of duration of the purpose.
13?
Paragraph 13, my lord.
Okay.
An order of blacklisting operates to prejudice the commercial person, not only the present, but puts the attachments beyond he may sell date. It is a civil date, madam. There is another judgment, my lord. I have given, my lord. Ramaja Constructions.
Which one?
This Ramraja Construction versus State of UP.
Where is that? Have you given it to me?
Yes, yes. Yes.
Yes.
Paragraph 24. Department is never permanent. For a period of development, it invariably depends upon the nature of offense committed by the.
In this case, how did you took out, the allegation is that you took out 10% of the earnest money?
But it was written by the authority itself. No. I have given the.
So according to you, it was returned, but how could he have taken it? There's no how. Did you put money in your,
No.
in your,
The bank guarantee which he has deposited to the department without the consent of the department, he himself has written to the bank and withdraws the. That is the-
he's withdrawn the,
without taking the consent from the department. That is the main case, doctor.
that is the mistake of the bank.
But without.
Bank guarantee is in favor of someone else.
Yes.
Once it is in favor of that person, then the bank should have spoken to him. Anyway,
Which what I have instructed from the department, the Krishna has forged the signature of the executive engineer, the then executive engineer, and submitted the same to the bank.
now 3 years have passed. I think it's more than enough. Plus, no notice has been issued by you. The end of the matter.
Which part I am not aware.
Then let us see your affidavit. Since you are not aware, let us
Yes.
go together. to your
Affidavit also is silent. on that-
Silent.
on that.
Let us see where he has said in your writ petition that no notice was issued.
Yes.
Even also is not suitable.
Paragraph 3, man. Page 9 of the writ petition. Not to speak about the so-called knowledge, even the impugn order was not communicated. It was on my request, knowledge, they have communicated with the impugn order. Page 3, knowledge. That the petitioner begged to state that on 15th November 2022, petitioner came to know from a reliable source that he had been blacklisted by the chief engineer, Water Resources Department of Assam. And upon inquiry with the concerned authority over phone,
Which, where have you said, Parag? Where have you said no notice was issued?
No,
even
nowhere.
impugn order was not issued.
Mr. Counsel, please understand the question. I'm not talking about even. I'm only questioning, I'm only asking you, where have you said that no notice was issued to you?
Paragraph 7 also, Malak, I have said, Malak, that unfair ex parte order. Paragraph 7, Malak.
Mr. Counsel, why you not, why not? Okay, he said has categorically failed to abide by the principle. How has he failed? No, acha, no reasonable opportunity to show cause matter. Yes, para 7 it is there. Para 7. Page 13. Let us see what is your reply to para 7.
Yes,
That-
Lordship. If Lordship comes to running page number 124,
Yeah.
our affidavit, paragraph 6. We have stated that with regard to paragraph number so and so of the writ petition, the deponent begs to state that before issuing the order of blacklisting to the contractors registered under the Water Resource Department, that notice is been left out, what notice that so-cause used to be issued to them by the department. Same principle was also applied with the petitioner. So-cause notice was issued to the petitioner by office letter number so and so, dated so and so. And the reminder letter was also issued by office letter number so and so, dated so and so. The aforesaid letters were issued on 2/5/22 and 10/5/22 respectively.
Annexure 2 and 3.
That those notice have not been annexed. Which is only about the some communication that they have sent page 120.
No, it has been annexure 2 and 3. That's right.
No, they say, but they have not. What should we check it?
Oh, yes. Annexure 2 and 3 are completely different. Not annexed. Yes.
Okay, then it has been left out of it.
Huh?
It has been left out of it. I will,
It has been left out. That is your fault.
Lordship, I will, Lordship, by
I will,
tomorrow,
you will what?
I will produce the same by tomorrow.
Tomorrow? Okay, we'll list it tomorrow.
Lordship,
Huh? It's okay. By tomorrow.
Lordship, I will.
You bring.
Yes, yes.
Right. The petitioner's case is that the blacklisting order has been issued without any show cause notice being issued to the petitioner. Para 6 of the affidavit in a position filed by the respondent number 2, bracket, chief engineer, is to the effect that show cause notice dated 2/5/22 and 10/5/22, which are annexures 2 and 3 respectively, have been issued to the petition prior to blacklisting the petition. However, annexure 2 and 3 of the affidavit filed by the respondent number 2 has not, is not in relation with any show cause notice dated 2/5/22 or 10/5/22. One chance is being provided to Mr. R.M. Das, Learned Counsel for the Water Resource Department, to produce the above said two letters as the present annexure 2 and 3 of the affidavit of the respondent number 2 implies that the chief engineer is trying to play hide and seek with facts, for which contempt of court may have to be initiated against the chief engineer. For which contempt of court and have to be initiated against the petition. Hence the response number 2. What is this? Leave this matter tomorrow. In the event Ms. R.M. Das does not bring the required documents and slash or does not have any instructions with regard to the same, the matter will be disposed tomorrow on the basis of materials on record.
I'm sorry, but it's there in the file.
Where?
No, it might,
It is there in the file,
in my file.
in your file, but it is not in my
Yes,
record.
yes, that's, it was an inadvertent mistake on my part. I do apologize for the same. 2/5/22 and 10.
This is not a show cause as required by the, as per the requirement, as per the decisions of the Supreme Court. There are so many decisions with as to how show cause notice with regard to blacklisting is to be done. Correct, right. That's all I think we have heard, it. We'll cut that. Heard Mr. S. Sharma, Learned Counsel for the petition. And Mr. R.M. Das, Learned Counsel for the Water Resource Department. The petitioner is aggrieved with the office order dated 13/5/2022. Where is this?
Page 39. 39.
Issued by the respondent number 2, by which he has been blacklisted for illegally withdrawing 2% earnest money of rupees 9,65,000, which was deposited against work order number so and so, it is CE/CC/ and so, dated 28/5/2022. For the work, it is here for the work. Okay, page 39. By the said impugned office order dated 13/5/22, the petitioner has also been informed that he will not be allowed to participate in the tender process of the department, and no renewal of registration would be allowed to him until further orders. Proceed. So this page 40, this office order, the subsequent one, is on the same issue, correct? Same issue, same issue. The petitioner is also, this para, the petitioner is also aggrieved with the subsequent office order dated 18/5/2022. Blacklisting the petitioner. Now, with the office order dated 18/5/2022, which superseded the earlier office order dated 13/5/2022. While the office order dated 18/5/2022, the petitioner has been blacklisted. In view of the criminal case registered by FIR number. Oh no, this is another earnest money. There are two earnest money they are taking.
One is from Nalbari,
Huh?
another is Porpeta.
Not true.
200.
200. Ah, that's good. Those were returned. What have I said? Returned by the? No, petitioner has. No, I been blacklisted. For illegally withdrawing 2% earnest money deposited against the schemes under, they take this, page 40. Okay. Next para. Then you take order dated 6/5/25, para 3, and para 4. Next. The petitioner's counsel submits that the petitioner was not issued any show cause notice prior to the issuance of the impugned orders dated 13/5, office orders dated 13/5/2022 and 18/5/2020. Prior to the issuance of the impugned. Whatever I said, please read. And 18/5/2020. And as such, the petitioner was not given an opportunity to rebut the defaults and breaches of contract. And to rebut the issues, to rebut the reason for blacklisting the petition. He also submits that there cannot be No, first off, in this regard, he has relied upon the decision of this court in the case of MS Feedback Infra Private Limited versus Union of India and two others reported in, no, not reported, WPC 2934/2020. Next. He also submits that a blacklisting order cannot operate in perpetuity. And in this regard, he has relied upon the judgment of the Supreme Court in the case of Vet India Pharmaceuticals Limited versus State of Uttar Pradesh and another AIR 2020 SC 5753. And in the division bench judgment of the Allahabad High Court in Ram Raja Constructions through its proprietor Jawhar Singh, Jauhar Singh, versus State of UP and four others. Reported in 2024, AHC 94730 DB. Next para. Mr. R.M. Das, the learned counsel for the Water Resource Department submits that the General Financial Power Rules 2017, which has been made by the Ministry of Finance, Government of India, is not applicable to the Power Resource Department, Water Resource Department, Government of India. He submits that the Water Resource Department has got its own guidelines. And in terms of clause J, comma, a contractor can be blacklisted on the following grounds, at J, J is there, which are as follows, This thing from here. No, from here, 1, 2, 1, 2, 7. Okay. He also submits that in terms of clause L of the guidelines applicable to the Water Resource Department, once a blacklisting order is issued, it shall not be revoked ordinarily unless The chief engineer is of the opinion that there is sufficient justification to revoke the order of blacklisting or the accused has been honorably acquitted by a court of law. That's all. Next. Mr. R. M. Das also submits that the respondents have issued show cause notice to the petitioner. Prior to blacklisting the petitioner while they impugned office orders dated 13/5/22 and 18/5/22.
2/5/22.
Huh?
2/5/22 and 10.
Correct. While
Ah,
letters, while show cause notice dated 2/5/22 and 10/5/22. He further submits that though he further submits that there has been a unintentional mistake while filing the affidavit in the possession of the respondent number 2. Inasmuch as the show cause notice dated 2/5/22 and 10/5/22 were to be annexed as annexure 2 and 3 in the affidavit. First of instead, they have by mistake, they have unintentionally annexed some other document. He has however submitted. No, full stop. That's not. Huh? He accordingly submits that as accordingly submits that in view of the blacklisting orders having been issued after following the guidelines, after issuing notices to the petitioner, the petitioner may submit a representation to the chief engineer, Water Resource Department, to take a decision as to whether the blacklisting of the petitioner should be revoked in terms of the guidelines applicable to the Water Resource Department. That's all. I have heard the learned process for the part. As can be seen from the submissions made by the counsels for the parties and the pleadings, the blacklisting order has been in operation for more than 3 years as on today. Next paragraph. The show cause notice dated 2/5/22 notices, date 2/5/22 and 10/5/22 which had been apparently furnished to the petitioner prior to the impugned blacklisting orders are reproduced herein below as follows. You put the date and you put from here to here, okay? As can be seen from the contents of the show cause notice, the petitioner has not been informed as to the precise case set up against him by the respondent. Full stop. The materials slash grounds on the basis of which okay, it is here. Has not material and ground upon which the department has sought to take action has only been reflected. Has only been to the effect that an FIR has been lodged against the petitioner at Nalbari Police Station. The show cause notice do not give particulars, specific particulars as to what default or breach committed by the petitioner has to be addressed. Next para. Though the guidelines that are applicable to the Water Resource Department provides that a contractor would be blacklisted in the event of any adverse police report against him, or in the event of any FIR being filed against the contractor, comma. The fact remains that the materials on the basis of which the FIR had been registered has not been furnished to the petitioner. Write the show cause notices dated 2/5/2022 and 10/5/2022. Further, it has also been stated at the bar that what there's a stay on the thing.
Yes, in one case, there is a. Very good. Okay. Two
two contracts, Malak. One is relating to
Which one has been stayed?
water.
Where is the order of stay?
I-
What are you doing?
I can get it.
You make submissions, you don't have documents.
Excel was 75.
Full stop. Next. In the case of then para 12 of the judgment in WPC 496 of 2022. Para 12, huh? Then no, do para 11 and 12. Para 11. Then it's in the case of MS Feedback Infra Private Limited, Supra. This court held that blacklisting of a person from for participating in future projects without issuance of notice was arbitrary and in violation of Article 14 of the Constitution. Then, right, next paragraph. The next issue to be decided is whether the blacklisting of the petitioner in perpetuity is permissible. Given the fact that the revocation of the blacklisting can be done by the chief engineer on being satisfied that there was sufficient justification for revoking the order of blacklisting. System. The other ground for revoking a blacklisting order is when the accused is honorably acquitted by a court of law. Yes, sir. Next question. In the case of Ram Raja Construction Supra, the division bench of the Allahabad High Court had held that debarment is never permanent, and the period of debarment would invariably depend upon the nature of the offence committed by the hearing contractor. Question. In the case of Vet India Pharmaceuticals Limited Supra, the Supreme Court has Isn't this 2014 SSC? 731. Are you got it? No, okay. Tara, where is it? Where does it say?
80,
Huh?
28.2. Last five.
Last line?
28.1
One.
and 28.2. Twenty-five is also this regarding permanency. Paragraph 25.
One. Whatever I said. No, you cut that in the case of, you say in the case of, instead of that, you put this. Okay, in the case of so, which has referred to another of its judgment in Ulja Industries Limited versus Chief General Manager, Western Telecom Project Bharat Sanchar Nigam Limited and others, 2014, 14 SCC 731. Has held that an order of permanent debarment was unjustified. Next, in the case of Kulja Industries Limited, Supra, the Supreme Court has held that debarment is never permanent, and the period of debarment would invariably depend upon the nature of the offense committed by the erring contractor. In the present case, the debarment appears to be permanent. And the same can be revoked only on the decision to be taken by the chief engineer, or if or if the petitioner is honorably acquitted in the criminal case filed against him by the respondent. However, the respondents seem to forget that an accused is presumed to be innocent until proven guilty beyond all reasonable doubt. In criminal cases, except for that's all. Ah, that's all. As such, the blacklisting of the petitioner in perpetuity and debarring him only on the ground that he has a criminal case does not appear to be reasonable. Further, more than 3 years have elapsed from the date of the order of debarment. The order of debarment / blacklisting. And as such, the continued blacklisting of the petition does not seem to be proper. Full stop. Next paragraph. The above being said, the fact remains that the respondents in the show cause notice have not stated the specific materials slash grounds which according to the state respondents necessitates the blacklisting of the petition. The blacklisting of a petitioner only on the ground that he has an FIR registered against him without giving the specifics relating to the FIR, which can be rebutted by the petitioner. Now, which would afford an opportunity to the petitioner to give a rebuttal to the same. What do I say? What do I say? The last sentence. In the view of this court does not warrant the blacklisting of the petition. There is also nothing to show in the show cause notice that the FIR that has been mentioned in the show cause notice dated 2/5/2022 has been furnished to the petition. Next one. In view of the above reasons, this court is of the view that what do? Do I say? Okay.
Set aside the order. Because if Lordship says he did some handle, he will get put in trouble.
There is no question of putting him in trouble, though.
Because after filing of the affair, they could have, that is the only thing. That is,
Actually, you did not submit, you did not give him a copy of the FIR. There is nothing here. You have just said, as reported by executive engineer, that a FIR has been lodged against him.
Yes, sir.
In view of this, please justify why you should not be blacklisted, and that's all you said, why you should not be blacklisted. That's all. You have not given a copy of the FIR also to him.
Immediately after lodging of the FIR, he has been arrested by the police.
Maybe, but then I'm not going by that. I'm going by this one. Out here, you have not given a FIR copy also to him. Supreme Court says that you have to give all the particulars on the basis of which you intend to blacklist. But you have only said that he has said in the report that you have a FIR, please justify, or else you'll be blacklisted. But you have not given the FIR to him. Next, what have I said? In view of the above reasons, and particularly due to the fact that no FIR has been furnished to the petitioner along with the show cause notice dated 2/5/2022 or 10/5/2022. This court is of the view that the impugned blacklisting order cannot survive. No, was not sustainable, according to the impugned, which order is it? Impugned office order dated.
13/5/2022.
Impugned office order dated 13/5/2022 and 18/5/2022. I hereby set aside. It is made clear that any observations or findings made in this petition does not have any bearing on the criminal case that has been registered against the petition. So, the writ petition is accordingly allowed. Obliged. Yes. Not free.
That is going on. Even with the.
Oh, we'll adjourn the matter then.
No, yeah, we got that, yes,
Even with the instruction.
reaching that, usually. Information which was.
1 to 42 still going on. Whole day. But have you seen this letter? Yeah, you should make copies for everyone. Yeah. Have you got?
I've seen that.
But this does not, now, so all the posts are vacant as
But
on
the
date.
3 posts are lying vacant, against which, the petition could be accommodated.
And what has happened to that private respondent? He has not turned up, no?
No, I'm appealing,
Oh, you're appealing.
I'm the number 4.
Okay, so that, so point number 4. And so there's been a stay. Or what?
There is an interim order, my lord.
So that's why you cannot,
My lord.
you
Because of this,
cannot.
I'm not getting the salary for the post for which I am holding down, my lord.
But why should you, how can you be promoted? That is what I,
No, but that's why part is the declaration made by the selection committee, my lord.
no, but
Sure,
on
on
what
the first
basis?
instance, my lord.
Huh?
Wait for the LDA is promoted to the post of the research assistant, my lord. This was not the first instance, my lord.
Okay, that's-
That is also recorded in the.
No, no, that one, the earlier one was a direct recruitment.
Directly. But in the next, my lord, in that promotional order, my lord, that I, definitely lordship, my lord.
One more thing, Lordship, another query was that shall obtain instruction as to who was holding the post of statistical assistant in SCRT Jorhat on 25/2/2016. That has got to be reflected.
Who was holding the post?
That has got to be. Huh?
Commission selection committee.
Not complicated.
Page, my lord, may draw your lordship attention to page 131, my lord. That is our Philippine official, my lord.
How are you entitled to go into this? Because you have got a service route,
No, my lord.
but you don't have any service route.
No, they are not holding.
But your promotional post is LDA. I mean UDA.
No, that is actually, my lord,
He has been holding the post of UDA,
Ah,
LDA.
LDA.
So his promotional post is
you,
LDA.
is
So UDA,
UDA.
UDA.
And you have taken the stand that you don't. Yes, what?
Page 131, my lord. Promotion of LDA, UDH and section assistant to the post of the research assistant under so, my lord. Shri Hemchandra Rabha, LDA, SCRT, Assam obtained the requisite qualification and qualifying service in the post of the LDA required for research assistant. Assam under establishment of expenditure so. The Assam has been promoted to the post of so having the required qualification and experience. Hence, the committee recommended that Shri Hemchandra Rabha, LDA, SCRT.
You are Hemchandra Baba.
Yes, he is also-
Oh, but then who can be promoted? That is the problem. Earlier, unless the rules are made, why? Now you're got no right to be promoted. Because I think, you see, for a research assistant to be promoted, to research assistant, even LDA and UDA both can,
Both of them.
can,
They're
why?
particular.
How? You all are different.
No, as per the advertisement itself, my lord.
But advertisement is only for direct recruitment. It
No,
is not for
no,
promotion. Yes.
No, next advertisement, my lord. Next advertisement.
Who took the dictation? But last one. Yes, another thing, this diet and SCRT, why shouldn't they be in one common seniority list?
Both are, both are, both are different catalogs and earlier also, they are for only for statistical assistance, they have make this combined gradation list. For other cadres of the diet and SCRT, they have prepared separate gradation list.
No, okay, for those statistical assistants of diet, what is their promotional post?
For statistical assistant of diet.
Diet.
Lordship for statistical assistance of diet.
Next to be research assistant, my lord.
Research assistant.
Research assistant.
Research assistant.
Research assistant for them. And from research assistant?
From research assistant, Lordship.
So if they're research assistant, so this is your research assistant,
Research assistant.
then
He is not holding the post of statistical.
I'm not talking about him. I'm talking about those persons in their combined gradation list.
Combined gradation is Lordship.
No, you see, the thing out there are two types of statistical assistants.
Right.
One is diet,
Diet.
one is this SCRT.
SCRT.
Now, for you, you're saying that your promotion post is research assistant.
Research assistant.
What is their promotional post? For those diet statistical assistant?
First of all, we have changed the common gradation list on.
No, I'm asking you. I know that. I know you're challenging. I know you want to separate. But my question is, what is the promotional post of statistical assistants of diet?
Research assistant.
Where? In diet only, or what? How many research assistant posts are there?
In diet, that's 23.
Research assistant,
23.
and in, thing, and in SCRT, three.
CRT divided 3 posts.
Three posts. So can you be considered for diet research assistant post?
No, if I am, my case is that those are different categories.
I'm not talking about your case, only I'm
therefore-
talking about everything.
Therefore, if I am concerned with SCRT,
Anyway, I think let the thing come, he just, so he will clarify.
complete instruction may be called for.
No, only मतलब देखो page 142 मतलब NHI 8 मतलब NHI 30 मतलब. This is the final graduation list of statistical assistant of the diet and SCRT मतलब.
I know, but he wants a separate list.
No, मतलब.
Now let us, you see, the issue is
Well,
whether the petitioner can also be considered for the post of research assistant in diet.
Right.
Let me see that also. Okay, right. The matter is adjourned due to due to Mr. Who?
Yes,
Yes, Bora, the counsel for the respondents number 2 and 3 being on legs in another court. Next paragraph. The council shall obtain instructions as to whether the statistical assistance of diet. No, statistical assistant. Of SCRT can be considered for promotion to the post of research assistants in diet. The number of posts of research assistants in diet shall also be obtained by the next day.
That's it. And regarding that paragraph 22, what instruction has been sought for on 25 to 2016, who was holding the post of statistical assistant. That instruction. is
Correct,
not
right,
available.
next. Mr. S. Bora shall also obtain instructions as to who was the statistical assistant holding the in the SCRT Jorhat on 25 to 2000. You make photocopy, I need that. You take a photo, give me that. This is the matter when.
can be on next Thursday मतलब on 22nd. No. So it is.
When?
Some difficulty.
Okay, when? Huh?
21st मतलब 21st.
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 Or 21st.
But that is the point. Not getting them.